Yes. Tell me.
Make please, Your Lordship. My lord, in regard to item number 31 and 49, I have a similar analogous matter. Same FIRs, there are many accused. My item is not before Your Lordship. I pray that my matter may also be taken up along with item number 31 and 49. The case diary is available, my learned friend has sent. They are all in custody.
Okay. Other matters are here?
Yes.
Before this court?
Yes.
Before this court. Okay.
Yes.
Make
Obliged.
My lord, I'm paying for listing of a matter, my lord. Long back notice was issued, my lord. The matter is not coming into
Today or tomorrow, this week?
on 26th.
May I please, Your Lordship? On the consent of the other side, I beg to mention item number 16 of the today's list.
16.
16,
Okay.
due to some personal difficulties of my senior, kindly the matter may be fixed on next Monday.
Next Monday.
Your Lordship.
Prayer, just the item 16. The prayer with the consent of the other side, the petitioner, learned petitioner council, 6 weeks adjournment, comma, which is allowed. List the matter on next to, what will be the date next week? Under the calendar. 1st December, 1/12. Okay. Interim order is there. Interim order, right? So and so date stands extended till the next date of listing. Yeah.
May please, Your Lordship, the item number 8, Lordship. List the matter, Lordship, appropriate bails, Lordship.
Okay.
Lordship.
Item number 8, matter may be on the prayer of the learned council, the matter may be listed before appropriate bench.
So another prayer for listing, Lordship. The next date is on 28, Lordship, on 26, Lordship.
May it please, Your Lordship, I beg to mention item 32 and 33. CD has not been received. 32 and 33.
32 and 33. CD is not received.
Kindly pass over the matter 43. Interim is there.
CD not receiving.
Okay. Interim is there.
Yes.
Interim is there. Case diary 32, 33. Case diary not received. Issue fresh requisition. Interim bails dated so and so and extended next date of listing. List the matter
15/12.
15 November. 5th of November.
15/12.
Achha, 15/12. Is that okay?
Published.
That's just instructions.
Lordship, in
Okay, go on.
item number 18, Lordship, I have filed an additional affidavit, but that has not been tagged with the record.
It will be brought.
Yeah.
Huh?
May I please, Your Lordship?
Yes.
Lordship, I beg to mention item number 48 of the supplementary list
48. Okay.
for withdrawal.
Oh, yeah. It is listed also. Anyway, you want to do it now?
Yes.
Your good name, please.
A. Chaudhary.
A. Chaudhary, Learned Council, for the petitioner seeks to withdraw this matter, bail petition upon instruction. The prayer is allowed, and accordingly, the instant bail petition stands disposed of upon withdrawal.
May I please, Your Lordship, I beg to mention for item number 28, Lordship.
28.
2. POXO matter.
Mhm.
Services is still awaiting, Lordship.
Okay. Scan report has been received. Scan report has been received. Scan report 28. Scan PCR received, but service report upon R2, respond number 2, is still awaited. The prosecution shall take instructions regarding service upon the informant through the concerned police station. Okay. List the matter. When do you suggest a date? 3/12. 3/12.
Can it be
4, yes, it can.
Obliged.
May it please, Your Lordship, I beg to mention item number 52 of the supplementary list here.
Okay.
We have filed a written objection
Mhm.
on Friday. That may be called for, Your Lordship.
Written objection. Okay.
Much obliged.
May I please, Your Lordship, I beg to mention for listing to criminal petition, Lordship. Next date is 28, Lordship.
Yeah.
May I please, Your Lordship, I beg to mention item number 34, Lordship. Lordship, FSL is not received, Lordship.
34, NDPS matter. Is it an NDPS matter?
No, my.
Okay. FSL, something else? Okay. Are you on interim?
No, Lordship.
No. Okay, as you wish. CD is received?
CD is rejected.
Not received.
CD receives
Okay.
9/12.
But CD you retain or send it back? Because
Because that FSL report not yet received.
not yet received.
Return and get the case.
34, case diary received but without FSL report. The call for the FSL report. The prosecution is at liberty to send back the case diary and procure it again if on the next day. List the matter on 12.
Lordship, I have another matter. Item number 51, Lordship. Service is not completed, Lordship.
Mm-hmm.
Service is not completed.
Okay. POXO,
Lordship, right?
service upon private respondent.
Yes.
51, service, it is submitted with service upon, what about case diary?
Well, in this case, as per my instruction, search sheet submitted.
Sure, should. Would you like to wait? Or something? It will come, but I don't know it will be. It should reach 51. Service report. Is it POXO matter? Yes, we don't not do seen the file, right? Should we do it now or you want to wait? Let it come up in the usual course, then we can pass it. Maybe charge sheet is submitted, so we can dispose it of. Perhaps.
POSCO is not 51. 51. No, my lord, this is not POSCO.
Not POXO. But diary is not received, right? The case diary is not received. However, the learned public additional PP submits that perhaps the case has already been charge sheeted. The petitioner counsel submits that service upon the informant, not yet complete.
Petitioner.
No, the service upon informant is not yet
informant.
complete. Prosecution shall take instructions regarding the service of notice through the concerned police station. In the meantime, issue fresh requisition for the scanned copy of the case diary along with the charge sheet. This is the matter on.
You will call for this.
Yeah, registry will do the needful. It's a BA, so
Yes.
when do you propose? Suggested date, you can suggest
On
December, Lordship.
yes, on 9th of December.
9/12. The calendar অলপ হেৰি কৰি আছে. It should be calendar এখন দেখা নাপাওঁ. No. Okay.
Problem.
Yeah, tell me.
Lordship, with the consent of the opposite party, I beg to mention item 20 for the passover of the day.
Eh?
Lordship, if it is court's convenient, can be fixed for Friday.
We can fix it on Friday. Let counsel for the petitioner submits that with the consent of the other side. She seeks an adjournment and prays for listing it on Friday. This is the matter on Friday is 28. Eh? I think 28 is. Any interim orders there? No?
One.
May I please, your lordship? This petitioner, he is in 77 days in the custody, arrested on 24/11/25, my lord,
Okay.
in a case of seizure of the heroin, my lord,
Okay.
from the possession of two other co-accused, my lord.
Mhm.
My lord, this case, my lord, this petitioner, he is a president of the Gaon Panchayat, and he was arrested after 3 months of the
Mhm.
registration of the FIR. man. After 3 months from his residence, when the main accused was arrested, after 3 months, my lord,
Mhm.
he was arrested, my lord. Now, he was already in 77 days in custody.
Mhm.
The allegation in this case, my lord, that on the basis of the co-accused statement,
He was arrested.
he was arrested, and there is a one phone CDR report between the co-accused, my lord.
Mhm.
But when during the investigation, that was the allegation, my lord, mainly. But in the charge sheet has been already been laid down. In the
Mhm.
charge sheet, interestingly, my lord, no CDR report has been
Annex.
annexed or put basis of,
They have given in the charge sheet also 21C has been given.
yes, ma'am.
Okay.
Charge sheet also 21C.
We have to see
And
37.
but the CDR report, that was not the part of the charge sheet.
Charge
file.
sheet.
But the initially, Malad, during
was-
investigation, that was the allegation
Mhm.
that there is a phone call between the other
Mhm.
two accused person.
And the already one accused person, my lord, page 42,
No,
he was granted bail. Lordship kindly see page 42. my lord.
Abul Hussain.
Yes, my lord.
Okay, fine. Since trial is not started, right?
Trial has not started, my lord.
Mm.
Recently, my lord, charge sheet has been laid down.
Mhm.
We have initially approached, my lord, before your lordship, then lordship has rejected and the matter, my lord. Here also, paragraph 5, what you can see, page 43, his allegation also same.
Mhm.
There's a phone call between the
Shamil Mohammed,
co-accused.
the
my lord.
father, okay. Only phone call is not the thing, but the context has to be seen. So should we call for the records?
Record has been called for, my lord.
We will call-
Record, yes, man, record is before your lord.
Because it was in motion state, so I.
My lord, initially in the motion state itself, my lord, record was called for, my lord.
We showcase this information.
I see, my lord.
Regarding receipt of the record not yet received.
Please for some time.
Record,
There's one order.
no, sorry, records needs to be called for.
Okay.
Last time
Yeah,
record
you-
to call not
okay.
for.
You call for the records. Karimganj? এনেকে আছিল যে চাবলৈ ভাল আছে হ'ব দিয়ক তো ভাল আছে কিবা বিহত ৰাখিছিল বা নাজানো মই Heard, we'll call for the records.
Well.
Okay. So heard learned senior counsel for assisted by and so for the petition.
Microphone, sorry.
As the case is stated to have been charge sheeted already. Therefore, call for the scanned copy of case record comprising case diary, the charge sheet, and other relevant documents, if any, of Patharkandi PS case number 133 of 25 under section 21C 2529 of the NDPS Act. The accused is stated to have been arrested on 8/9/2025. List the matter. When do you like it to be?
As soon
We
as
have to give,
possible.
that's true. We have to give 1 week, I think. But third and fourth, I mean, maybe well, it may change also, Ross. Third and fourth, I will not be available. Third and fourth. I'll be here, but I have to take leave. So it can be on, say, fifth. Fifth, fifth, 5th. It can be other points.
Public.
Yes.
May I please your honor? Sir, I take the notice in page 13, that is the affairs.
Mm.
It is a case of 483 for regular bail, my lord.
Mhm.
In fact, he is 58 days. He was arrested on 28/9/25 in a
Mhm.
different case, my lord.
Mhm.
But he was shown arrested here in the instant case
Mhm.
on 4/11, my
I
lord.
see.
And your lordship knows there is a judgment of the appeals court that if there is a pending cases against me,
Mhm.
it must be disclosed to me.
Brought to the
This
notice.
case was not done.
Mhm.
And moreover, my lord, there is a serious allegation has been lodged against the IO before the Human Rights Commission and the DGP. An inquiry has been ordered. There is a tremendous pressure upon me to withdraw the allegations, my lord, that I have annexed, my lord, the findings of the CGM also. Now, my lord, in this case, I take your lordship page 13, kindly peruse the affair. It is respectfully submitted that on 11/9/25 at about 10:45 p.m. I parked my car near my friend's residence at Nandan Nagar, Barbari, and stayed there for the night. And today morning at about 4:30 a.m., I came to know that my car has been missing from that place where I have parked my car. I have searched the nearby area, but I have no information about my car. Car number is such and such. Case was registered under 406, my lord. Car has been stolen. How the case of 406 has been registered? Tremendous failure on the part of the IS. Then you come to the matter, kindly come to forwarding report, page 17, minutes. Completely different thing has been projected. Kindly, minute. With
Page
refer
17?
page 17, minute.
Mhm.
With reference to the subject cited above, I have the honor to report that on 12 March, when the Biju Gaokhua, son of such and such, during the preliminary investigation, Vishwajit Devnath of Dispur PS found that one Devojit Bhattacharya made an agreement and fraudulently taken away the vehicle Maruti car such and such, bearing registration number such and such, engine number such and such, chassis number is such, and from the residence of Swaraj, resident Hangrawadi, and approached him under the pretext of providing various work opportunities. Devajit Bhattacharya offered, complained that one vehicle is urgent need as a monthly rent under the school purpose, and he has promised to Biju Gaokua a payment of rupees 30,000 per month. After that day, the accused did not respond to the call for the complaint. Accordingly, the case has been registered in dispute PS case number such and such 316. What is the link, my lord? What is the FIR? What is the forwarding, my lord? Intentionally, he has been shown arrested, my lord, by the IO, my lord.
He was arrested in this case,
Yes.
dispute PS case.
This per case says, my lord, 4-1, 4-11, my lord. Today I am before your lordship.
And this one is?
This was case, my lord. This case, dispute case number 8886, my lord, 25. 316. Breach of
886.
trust, my lord.
Right.
And in this case, I have been shown arrested on 4-11.
411.
4-11. Today is, my lord, 24-11.
Nice.
So I pray, my lord, kindly grant him bail, my lord. There is a contradictory, you see the forwarding in the FIR. In fact, total my detention is 58 days, my lord.
Yes.
Your lordship may kindly come to page 16, my lord. Third paragraph, my lord.
Mhm.
Regarding
paragraph?
the third paragraph, my lord, during investigation,
Achha.
page 16.
Yeah, I've seen this. Yes.
Monthly rental or in sale price purpose, but for their wrongful gain, my lord, fourth line, the accused illegally sold those vehicles at Manipur and Nagaland, my lord.
What
In
is
the
the link in
current
the
case,
FIR,
the
my lord?
vehicle was taken, so their modus operandi, my lord.
Is it this? What are the sections in this case?
3162 and
316, that is 406, my lord. Breach of trust,
The 60 days.
60 days.
60 days.
Then
Based
we'll
on
have to
trust,
fix it on
If
after
any
3
other-
days.
8 days I am behind the bar,
I
my
will
lord.
have to, my lord, get the instruction whether any other sections added or not, because, my
You
lord.
get the case diary and the instructions, and we'll fix on the 61st day. Right?
Yes, Thursday.
Today 58 days, right?
58 days, my lord.
Friday will be 61 days.
Yes, Friday.
Hmm?
Friday, yes, I can get it.
Heard SC Viswas Learned Council, additional PPP Bothago. Stop. The present accused is stated to have been shown arrested
On 4-11.
on 4/11/2025 in the instant case, that is dispute PS case number 886 of 25 under section 316 within bracket 2 BNS. Stop. Call for the case diary from the concerned police station. The prosecution shall also take instructions as to whether any other penal provisions have also been added in the meantime. List the matter on 28, 28. 28, 11. 28, 11.
Number 3.
Please, your regular bail application. Petitioner is behind the bar for the last 40 days here. A special PP for forest here.
Forest offense.
He is not there.
Have you served a copy?
Yes.
You served a copy. Should be here. actually.
Before filing, we have served.
He should have been here. Should we call for the this case diary or offense report, whatever?
I
it
have
is?
some submission of ground of arrest here.
Then let him come. Then you inform him. We'll take it up after some time. Grounds of arrest.
Number 4.
May I please, your
Yeah.
lordship? This is regarding lordship purchase of stolen good lordship. May I
Relax.
pray, can it be on Friday lordship for case diary because of some health complication is also there lordship.
It comes, it's of.
From Gottschuk lord.
Hmm?
Gottschuk.
Of course. Will come.
Friday will have
Hopefully will come. Call for the case diary of Gorsuk PS case number 315 of 25 under section so and so. The accused was arrested on 17/11/2025. Call for the case diary. of so and so to call it, list on 28/11.
Much obliged, Your Lordship, much obliged.
To the third time bail application, Lordship, under section 103. So the today is 84 days, Lordship.
Okay.
During the length of detention, I may go on bail, Lordship. Your Lordship have produced the CD for twice. So
Earlier bail petition,
Earlier bail.
subsequent bail petition.
Yes, Lordship.
Okay.
So today is 84 days.
Oh, I see. That case. Mhm. You take instructions.
Yes, your lordship may kindly fix it today on,
Kyle?
no,
84 days, right?
on
So
1st of December, Monday.
That is
can it be on Friday?
Yes, Friday.
Friday for
Hello.
Friday.
Third non-council occasion. It is fairly submitted that this is a subsequent bail petition and as earlier bail petition was rejected by this court on 30/10/2025 in BA 3370 of 2025. The accused is stated to have completed 84 days in pre-trial detention. Call for the updated case diary to ascertain the latest stage of investigation. List the matter on 28/11.
Number
6.
May I please the lordship?
Mhm.
Lordship, scan copy was required.
Call for the scan copy. Charge sheeted case. Trial has started? Trial, not sure. Trial has started. It's started. So because I'm asking because in case of trial starting, we'll need some depositions also. We'll call for depositions also. Call for the heard so and so. DRI, yeah? Standing Counsel DRI. Call for the scan case record of NDPS case number 315 of 2024 under so and so sections pending before the, where is it pending?
The district and sessions are two. additional two.
Two, number two, additional sessions as number two, Kamrup Metro Guwahati. The police case number two, likhi dibo, DRI case number 26/so and so. Full stop. The accused was stated to have been arrested on 10/3/2024. List the matter. Let us fix it.
8 of December.
All right, 8 of December. Okay.
Okay.
Item number 7.
Yeah.
Here, this is with all respect, Madam. This matter went up to apex court because, my lord, the learned, the Honorable Guwahati High Court granted the accused the privilege of bail, my lord, with all respect on default ground, my lord.
Yes.
But it was this, then when it was challenged at the apex court, my lord, apex court said that, my lord, with all respect, my lord, it was not a 60-day period offense, but it was a 90-day period offense, my lord. Hence, it was remanded back, my lord. And my lord, primarily, my lord.
Thereafter, this was filed.
Thereafter, my lord, we moved the Court of Sessions.
Aye.
There, my lord, what happened? There is a total violation of apparent on face of the record. They file affidavits also, my lord. They cannot develop it now, my lord. It was violation of 47 and 48, my lord. The question is this, my lord. This violation of 47 and 48 was not before the High Court. Although, my lord, it was there in the application, because, my lord, it was granted on the ground of default, my lord. That they could not file challan, my lord, within 60 days, my lord. Have I made my position clear, my lord? And thereafter, after being remanded back, again we took up this thing, grounds of violation of 47 and 48 because of the authority of Babu Singh, my lord. When there is constitutional right violation, it can be raised at any point of time. Because earlier orders were ab silentio, my lord. That point was never discussed, my lord. With all respect, my lord. May I just come to why the learned sessions, sorry, my lord, the learned special judge, CBI rejected it this time. My lord, he took a, my lord, that is that, my lord, with all respect, my lord.
What page?
That exactly, Albert. 115, my lord. This is a preposterous, that should not have happened possibly. I think it was a revision application, my lord. Can I just
115.
115 para 41, my lord. May I read, my lord? With all respect, my lord. Even though this court has no any jurisdiction to re-enter on the subject of non-compliance of provisions of section 47 and 48 BNSS, as my learned predecessor, I.E. Session Judge Dibrugarh, already passed the order upon it that this court can look after the subsequent development of the case pending before this court to dispose the bail application filed by the accused. Weird understanding of law, my lord. Then let me come to the order of the session judge, my lord. Have I made my position clear, my lord? The session judge rejected it 2 number of times, my lord, and those occur at, first one is at page 36. Although the plea was taken, my lord, but he disposed it of absolutely on merit, my lord. Lordship may have found
Page 36.
36, my lord, of our application, my lord.
Yes. Session Judge Dibrugarh, yes.
This is the first rejection, my lord. My lord, with all respect, my lord,
Yes.
the last parting paragraph, my lord.
Yes.
After perusal of the CP and considering the nature and gravity of the offense and seriousness of facts stated in the FIR, alleging fraud of huge amount of public money, and also considering the nascent stage of investigation, I am of the considered opinion that really, have I made my position clear, my lord? 47, 48, although we raised, it was never the contention here and never, my lord, taken into consideration by the learned session judge, my lord. And if you would have taken it into consideration also, my lord, the paragraph by which the learned special that this time has rejected the application is, my lord, beyond the provisions of law, my lord. They here nowhere discuss section 47, 48, and thereafter the second rejection order, my lord, with all respect, my lord, that occurs at page 42, my lord. 42 is rejected, my lord, with all respect, my lord, para 7, my lord. May I read, my lord? From perusal of the case diary, I find that the FIR is registered under so and so, it goes on and on, my lord, and has been in judicial custody considering the materials in the case diary and involvement of huge amount of public money. Have I made my position clear, my lord? 47, 48 was never taken into consideration. And before the High Court, although we stated in the application, my lord, and before the High Court, when Honorable High Court granted the privilege of bail, it was on the ground of default, my lord. So no question of considering 47 and 48. And may I read the apex court order, my lord? There also it is cited, ab silentio, my lord, with all respect, my lord. The apex court order is at 87, my lord. If I begin from 87, if I continue, my lord, in entirety, no mention of 47 and 48. Para 5 is very important, my lord, that occurs at page 89. May I, my lord?
Yeah.
My lord, with all respect, my lord, in such circumstances, in our considered opinion, the ground on which the respondent has been released on bail is not justifiable. Therefore, we set aside the order passed by the High Court and direct the respondent to surrender within a period of 2 weeks from today. Otherwise, the petitioner is at liberty to take him into custody. With all respect, my lord. Thereafter, my lord, we further make it clear that after surrender and on applying for regular bail afresh by the respondent, it shall be considered on its own merits. Have I made my position clear, my lord?
Yeah.
And uninfluenced by any of the observations made by this court in this order. Here I say, my lord, that it was on default because para 4 may be, my lord. Again, I am taking it backward,
Yeah,
my lord.
seen.
My lord.
It was a mistake regarding statutory
Absolutely,
period.
absolutely. Now, my lord.
Amended back.
Now, my lord, can I just place the notices before your lordship? Absolutely blank, my lord. The notices are, my lord, 121, my lord. After all, that this BNSS would be applicable to them also, my lord. Let it be Scotland Yard also, it would be applicable to them. Para 121, my lord, with all respect, my lord. Page, my lord. Lordship may have found it, my
I
lord.
found it.
Kindly see, my lord. In my lord, with all respect, my lord. Journalist pronoun ki ase? In Probir Purukayastha, there it has been, my lord, in para 48 categorically stated, even reasons of arrest won't do, my lord. That I'll read, my lord. Absolutely blank, my lord. And we are prejudiced to the effect that we did not finally bail application on the first day of production, my lord. Have I made my position clear? I'll read
Yes.
that order also.
Yes.
This is 47.
Hmm.
No mention of anything, my lord. Not even the reasons of arrest, my lord. Not to talk of grounds of arrest. As is postulated under Article 22(1), my lord.
Mhm.
Withhold. Thereafter, my lord, 48, my lord. Same. Next page.
Mhm.
They cannot develop it, my lord. 48, my lord.
I've seen.
Absolutely blank. Now, my lord, that we were prejudiced because first, my lord,
When was he arrested initially?
he was arrested initially, my lord,
4-9.
49,
4-9.
59. What is from 59?
4 and 5.
59. Now, my lord, only
Page 17,
page 17,
para 13.
para 13.
By this time, trial must be on. No? Trial must be on.
Part charge.
Part search sheet has been
Oh,
submitted.
I see.
Parts are there.
Long time.
My lord, only thing, my lord, in their affidavit they file. Now, if they say that we want to file affidavit, that will be possibly preposterous. Can I just place it, my lord?
Mhm.
They make their own law, my lord. That cannot happen. BNSS is applicable to all. My lord, may I just read it and place it before your lordships, my lord?
Mm.
With all respect, my lord. There they filed 2 affidavits before the learned special judge, while after being remanded, after surrender, as per the order of the Honorable Apex Court, we moved the special judge, or learned special judge, my lord. There they filed affidavit.
Mm.
This affidavit, it occurs at para 8, my lord.
Mm.
First affidavit, my lord.
Mhm.
Lordship may have found, my lord.
Yes.
That at the time of arrest, the investigating officer has served a notice under section 47 of the BNSS and upon accused person clearly mentioning the reference case number and specifically inform him that he was being arrested. In this manner, this affidavit was filed. They cannot develop it, my lord, in connection with the state case, thereby duly complying with the requirement of section 47(1). I read the 47 notice before your lordships, my lord, with all respect, my lord. Absolutely blank, my lord. Not to talk of, my lord, grounds of arrest as is postulated by the Constitution and thereafter 47, my lord.
Yeah.
And second affidavit they filed, my lord.
The other one.
Another one affidavit they filed, my lord. There it occurs at para 14, my lord. Trying to negate, but in a preposterous manner, my lord. That occurs at para 14, my lord.
Yes. That in reply to the.
In para 10, we stated, my lord, that there is total clear violation of 47 and 48, my lord, section 47 and 48 notice, that in reply to the amendment made in para 10, it is submitted that the allegation that the arrest procedures are not followed is wholly baseless. The arrest of the petitioner was carried out strictly in accordance with law, after due service of notice and communication of grants as required under the BNSS. If I am to reread the notices, my lord, notices were served, no two ways about it, but it was blank to the extent that, my lord, with all respect, my lord, no grounds of arrest were provided, not to talk of grounds of arrest, even reasons of arrest were not provided. Then, my lord, just for the sake of repetition, my lord, can I come to, my lord, Probir Purukayesto? That is still good law, my lord, because of the Nia case, my lord. Because this that actor, my lord, Darshan, my lord, was contrary to, my lord, Probir Purukayesto and Vihan, my lord. But as our High Court division bench has said, my lord, honestly, categorically, crystal clear, my lord, that the earlier laws would prevail, my lord, and that would be, my lord, prevalence of Vihan and, my lord, Probir Purukayesto. In Probir Purukayesto, one paragraph, my lord, that nails their coffin, my lord, that occurs here, with all respect, my lord. Para 48, my lord.
Yes. Written.
Para 48, my lord, with all respect, my lord.
Mhm.
May,
Go ahead.
my lord. It may be reiterated at the cost of repetition that there is a significant difference in phrase reason for arrest and grounds of arrest. The reason for arrest, as indicated in the arrest memo, are purely formal parameters, that is, to prevent the accused from committing any further offense, whatever has been provided in 41A earlier, my lord, for proper investigation of the offense, to prevent the accused from causing the evidence of the offense, and these to disappear or tampering with such evidence in any manner to prevent the arrested person from making inducement, threat, or promise to any person acquainted with the facts of the case so as to dissuade him from disclosing such facts to the court or to the investigating officer. Even this is missing.
Generic, these are generic.
Generic. And thereafter, my lord, the reasons, these reasons could commonly apply to any person arrested on charge of a crime. Whereas, this is very important, my lord.
Grounds are specific to the.
Whereas the grounds of arrest, I should not continue.
So-
Because here, even reasons of arrest are absent, my lord. Not to talk of grounds of arrest. Absolutely a notice was served that you are arrested. Because otherwise, if they do not provide me with the grounds of arrest, I'll be, my lord, with curtailed from my right to move a bail application if remand is sought to prevent it, my lord, to pray for preventing it, my lord. So, my lord, absolutely prejudice, my lord. And the law has been violated, absolutely clear terms, my lord. They cannot, my lord, repair it by any affidavit or anything, my lord. With all respect and full defense.
Me come to her.
And
You are,
can I come to silencio part, my lord? When we are that apex court authority, my lord,
right,
it is not discussed. Have I made my question clear, my lord?
yes.
Because it was granted on the ground of default, it was rejected by my lord, where the bail was cancelled. Only because the reason that, my lord, the period was either way, my lord. With all respect and full defense.
There was a defect, there was an error in calculating the period.
Absolutely. And thereafter, my lord, with all respect, my lord, in the apex court order, nothing was discussed. So for a violation of section 47
Yes.
and 48, can I just?
Because perhaps it was not required to be discussed or it was not contended, perhaps.
Absolutely. Because it was.
It's okay.
It was, sorry, my lord, it was on the ground of default, my lord. Now, my lord, sub silencio, when something is not discussed, my lord, that cannot be agitated by the other side, my lord. I'm just reading, my lord, it will take 2 minutes, my lord. 1989,
Yeah.
1 SCC, page 101. The parties are, my lord, the participants were, my lord, Municipal Corporation of Delhi versus Gurnam Kaur. There it occurs, my lord, with all respect, my lord, para 11, parting paragraph, my lord. A decision,
Yes.
a decision passes sub silencio in the technical sense that has come to be attached to that phrase when the particular point of law involved in the decision is not received by the court or present to its mind. Have I made my position clear, my lord? 47, 48 was never before the Honorable Apex Court, my lord. This court may consciously decide in favor of one party because of point A, which it considers and pronounces upon. It may be shown, however, that logically the court should not have decided in favor of the particular party unless it also decided point B in his favor, meaning thereby 47, 48, because point A was default, my lord. Favor of the particular party unless it is also decided by D in his favor. But point B was not argued or considered by the court. So section 47, 48 was never before the apex court. In such circumstances, although point B was logically involved in the facts, that is a default, my lord. Although the case has a specific outcome, the decision is not an authority on point B, meaning thereby section 47 and 48, it, my lord, holds ground, and it say, my lord, they cannot repair it by, the damage cannot be repaired. My lord, there is incurable damage, my lord, that can never be, my lord, they can, by any affidavit or anything, my lord, they cannot repair it, my lord. After a total violation of 22(1) and consequently section 47 and 48, my lord, with all respect and full
Yes.
respect.
Okay, I come to you. You're appearing for CBI. Yes, go ahead.
2 weeks time to file our reply in this regard.
Because since he's contending this 47, 48 notice, so at this stage, the first thing we should do, I think, get the case diary, and because this is also one of the principles laid down in Vihan Kumar, as you would be knowing, that whenever this contention is made that this is being violated, the prosecution is asked to say that whatever have their say on that. So we can call for get the record case diary.
It is investigated by Delhi branch, so 2 weeks time.
It's special crimes, not anti-corruption.
Not anti-corruption.
Special crimes, Calcutta, I think, Calcutta.
No, Lordship, Delhi branch.
Well, if I read one, of course, my lord, I am not trying
Because
to say,
prima
my
facie, Of course, there must be correct document because, but it is always our duty to cross-check
My
it
lord.
once from the official, your records, right?
Can I just say, we Lordship is very correct, my lord. She is also, what I am saying, my lord. Though of course, I am not reading it, my lord. When it is, my lord, apparent on face of the record, definitely, my lord, Lordship would give them time, my lord.
Mhm.
But that 15 days is uncalled for, my lord. Let them give it, even not, whatever they need to send, at least, my lord, they are to prepone
You
it.
can
my
take
lord.
instructions also
Exactly,
regarding this
exactly, my lord.
compliance. You can take-
Exactly.
I will know, I will, in the order, I will write, call for the diary only, diary and, but you can also take instructions regarding the
Absolutely.
compliance, because, you know, what I say, in my humble opinion, that if there is, suppose the 4748 has not been complied with, then every day of detention is untenable.
Absolutely.
So that
Absolutely.
way we can give an interim, but considering the nature of the materials also, there is some, there might be some hesitation. So you do that. That will be the best way forward.
No, no.
And this a week, at least, you know, even if the record takes some time or your objection takes some time, get the instructions regarding the compliance. Okay,
My lord, that affidavit.
within a
proves
week.
everything.
Within a week.
Regarding him, investigation is complete, my lord.
Okay. Third, learned counsel. Let's stop. The instant application has been filed under 483. I won't say much now. 483 BNSS seeking bail for accused Ranjit Kakoti, who is in custody. Who is in custody since 5/9/2024 in connection with FIR number RC so and so date pertaining to Dibrugarh PS case number. The case was subsequently investigated by the CBI and charge sheet. However, it is submitted that trial has not yet started. Full stop. Your good name, please.
The Lordship MSN Chaudhary.
Also heard so and so for the appearing for the CBI. The learned counsel for the petitioner submits that in an earlier round of litigation, the petitioner was granted statutory bail vis-a-vis statutory period of 60 days. Full stop. The same was taken up before the. It was confirmed by the High Court, right? It was given by the High Court. Oh, by this court. The CBI took up the matter to the Honorable Apex Court, where it became clear that the applicable statutory period was actually 90 days. And accordingly, the matter was remanded back, whereupon bail petition was preferred before the learned trial court, also taking the grounds of non-compliance under 4748 BNSS. However, the said petition came to be rejected. In this backdrop, the petitioner is before this court. The learned counsel, drawing attention to the copies of the said notices under 4748 annexed with the bail petition, submits that the Honorable Apex Court had not gone into that aspect of the matter, and that there is a violation of the note or the stipulations regarding these notices. And in terms of the governing law, the petitioner should be granted bail. The learned counsel for the CBI seeks 2 weeks' time to file a reply first. The CBI is at liberty to file any reply. However, call for the scanned copy of the case record comprising case diary and charge sheet, including the documents under 4748 BNSS. The learned standing counsel CBI shall also take instructions from the investigating authority regarding the compliance of 4748 BNSS. Okay. You can take instructions. Can we fix the matter on next week when Tuesday next week? Okay. That will be second. Second. Just check it. It's a matter of fact. No, we should never run away from facts. Facts are facts. We should face it. You know, it's not there, not there. Next time you follow it. It's like that.
Hello, can it be possibly it will be from the court, my lord, partly?
It will be from the court only. It will be from the court only.
That-
Sorry,
that's
sorry.
good.
Thank you for
I'm
pointing.
sorry.
Special, no, you're right. Special additional CBI court number. Where is it pending? Can
No,
you-
yeah, I'm sorry.
Nimish, can you help me with that? CBI,
I'm sorry. Kundu?
it will be one of the CBI courts.
Two. CBI court number two, ma.
Okay. Additional CBI court number two,
Two. And my lord, date of surrender is 310, my lord.
310.
Some other date was given, my lord.
It is submitted that the petitioner had submitted before the investigating agency on 3/10/2025.
Wait, not before the investigation, before the court, my lord.
I see. So 3/10, no, 5/9 is the,
It was arrested.
Arrest, my lord. 310 we surrendered, my lord. Thereafter he went out on bail, my lord.
oh, I
Thereafter
see.
it was challenged, my lord.
অলপমান লিখিব লাগিব ডট ৰাখিছো ডট 310 dot
Date of surrender, my lord.
date of sign. So he is in custody since
3/10.
3/10/20.
25.
This year, my lord.
Oh, this year. Okay. In between, he was on bail.
My lord.
Yes. He surrendered on 3/10/2025 after being on bail after his initial arrest.
My lord, highly obliged, my lord. Obliged.
Okay, fine.
Obliged.
Item number 9.
Not 82 application, my lord. FIR is at place, my lord. 9, my lord. Here, my lord.
It's an AB, right?
My lord.
Mhm.
My lord, here, my lord, informant and my lord, the petitioners are my lord friends, my lord.
Mhm.
They, my lord, carry out some business of purchasing and selling of, my lord, used cars.
Mhm.
And my lord, there are some dispute regarding the, my lord, capitals, my lord, and my lord. On the day of occurrence, my lord, there is some hot exchange between the parties, my lord. And regarding their capital. Thereafter, on the following day, my lord, this case has been filed. Initially, it was filed at Hatiwa Pier. There on the same has been transferred to Dispur Pier.
Jonakpur.
My lord. My lord, one poor fish has been, my lord, arrested. And I have annexed his arrest memo, my lord, at place, my lord, 13. Annexed 2.
Mhm.
Here, you Lakshmi kindly say, my lord, ground number 3, my lord.
Mhm.
During investigation upon examination of victim, it came to light that he personally knows you as both of you were jointly involved in business activities.
Mhm.
Well, they carry out some business, my lord. Well, at this stage, my lord, I pray your lordship, my lord. He will call for some protection will be given to me. I will declare, my lord, that.
My lord, yes.
Only half an hour, my lord, he has, young boy, my lord, he has come back. to-
Although they are in business activities, my lord, they are together, my lord. Lordship may kindly peruse at page 10, my lord.
The relation sword.
FIR, my lord. He was taken away by the other accused
The
party.
allegation, my lord.
And
There's some allegations, yes.
some allegations are there, my lord.
My lord, schedule, my lord, clarify everything, my lord. Schedule.
Lordship may also sort that, my city, my lord, sort that, I will produce it.
No demand, nothing, my lord. No.
They were doing transport business
Yes, my lord.
together, right?
My lord, actually, they, my lord, purchase, my lord, use cars and sell it, my lord.
Heard. Your good name? Bis. P. B. Yes, sorry, I'm getting to know you now.
Right.
The petitioner is seeking prior's bail, invoking the provisions of section 482 BNSS in connection with dispute PS case number 807 of 25 under so and so section. The petitioners, the case arose out of an FIR dated 25/9/2025 lodged by Biswajit Das with the allegations that on 24/9/2025 at around 8 p.m. 4 or 5 youths forcibly picked him up in a Bolero vehicle and took him to a house and where he was assaulted with an intention to kill, and that he sustained multiple injuries on the body first. Both the petitioners are named in the FIR. It is submitted by the learned petitioner counsel that the informant and the accused petitioners were doing business together of purchasing used vehicles and selling them. But some misunderstanding cropped up. And eventually this criminal case was lodged. Full stop. The learned counsel seeks some interim protection till disposal of the petition. Call for the case diary from the concerned police station. However, in the interim, in the event of arrest of the petitioners in connection with this case, 25,000 each. Subject to the conditions that they shall appear, they shall cooperate in investigation and appear before the IO, making themselves available for examination. Number 3, shall not hamper or tamper with evidence. Number 4, shall not in any manner intimidate, harass or harm the informant and his family. List the matter on.
16,
16.
12. 16, 12.
File establishment.
Developers.
Supply data DA assessment.
May it please, Allah, sir. Allah, this is an application for pre-arrest bail, my lord.
Yes.
Now, what had happened, my lord, the FIR was lodged primarily raising the grievance that this executive of NHI DCL, my lord, he demanded some money to do a favor in the sense that we will grant extension and issue a completion certificate.
Project.
Now, my lord, as far as the main allegation that person who handed over the bribe, he has been enlarged on bail. And I am one of the partner of the firm, my lord. Basically, there is no specific allegation against me. In the FIR, my name finds place only as a partner of the firm.
Okay.
And secondly, my lord, in the post-trap memorandum, there's absolutely nothing against me.
It was a trap case.
Yes. Now, if your lordship would kindly come to the order passed by a coordinate bench in the other case, my lord, at page 58,
Yes.
this will clearly show, my lord, that I have no role. Para 16. It is seen from the records at page 58, my lord. It is seen from the records that the accused applicant is a manager working in the partnership firm, namely Mohanlal Jain, located in Kolkata, which is involved in executing certain EPC contract in Dibrugarh, wherein NHI DCL is also a party representing the government. It is also seen that the accused applicant was in fact arrested from the office of the NHI DCL located in Guwahati. However, as per version of the CBI in the post-trip memorandum of recovery and seizure and the grounds of arrest of CBI provided in notices under section 47 and 48 of BNSS, there is a striking difference relating to the time of interception and arrest of the accused applicant by the CBI. It is apparent on perusal of the aforesaid document, though the CBI in their grounds of arrest mentioned that the accused applicant was caught red-handed while bribing the co-accused, namely so-and-so. However, in the post-trip memorandum of recovery and seizure dated 14/10/20, it has been specifically mentioned that the accused applicant was apprehended while he was coming out of the chamber of the aforesaid accused. Therefore, these two versions of the CBI do not say same thing, and therefore it cannot be prima facie ascertained at this stage as to which version of the CBI story is correct. In case of trap relating to bribery, sequence of events is of utmost importance and there should not be any missing link relating. So now kindly see, my lord, the entire incident is being narrated in the order where my role is not even, my lord, envisaged anywhere. Therefore, my lord, since my name appears in the FIR, my lord, I am apprehending that I may be taken into custody. Meanwhile, lordship may call for the CD, my lord, but in the meantime, I'll pray for some protection, my lord. Privacy in the FIR also there is
Can we see
nothing.
the FIR?
Yes, sir.
So page.
FIR is at page 18.
Yes.
Now please come to page 19, my lord. Earlier they narrate that this Moran bypass was given to this particular contractor.
He's Amit Jain, right?
Yes, I'm Amit Jain.
Amit Jain.
And my lord, the party completed the work, but there was some delay.
Just a minute.
Yes, page 19, my lord. First subparagraph. Sources further reveal that on 17/9/25, Vinod Kumar Jain informed Sri so-and-so of NHI DCL that the firm Mohanlal has completed the emergency landing facility contract at Dibrugarh and also submitted the request for grant of extension of time and issuance of completion certificate. Sri Vinod Kumar Jain also expressed that they desire to meet so-and-so for issuance of their EOT and completion certificate. Maisam Riten Singh advised Vinod Kumar Jain to visit him at the Guwahati office. Sources further reveal that on 10/10/25, Vinod Kumar Jain conveyed to Amit Jain, that is the petitioner, that they have to visit the executive director of NHIDCL at Guwahati either on 13 or 14. Vinod Kumar Jain further conveyed that their file was pending with one Vinayak, with Amit Jain asking Vinod Kumar Jain to talk with the executive director and inform him that their completion certificate file was pending and to further seek an appointment from the executive director of NHIDCL. Amit Jain further conveyed to Vinod Jain that they have to deliver a total amount of so-and-so as demanded by the executive director. Later on the same day, Vinod Kumar Jain conveyed to Amit Jain that he had received a message from executive director conveying that he was presently at Silchar and would be reached Guwahati on Monday. Sri Vinod Kumar Jain further conveyed Amit Jain that he will be sending a message to the executive director of NHIDCL conveying that he would reach Guwahati on 14. Later on the same day, Sri Vinod Kumar Jain again conveyed to Amit Jain that executive director has agreed to meet him on 14/10. Sources also reveal that there is every likelihood that demanded bribe of 10 lakh will be delivered by Vinod Kumar Jain, representative of the firm, etc., etc. So this is the allegation, my lord. Now, my lord, yes, I asked him to meet because
Yeah.
my things are pending.
When can you get the case diary, madam? Can you get it on Wednesday, day after tomorrow? That is
Lordship, Thursday.
Thursday,
Thursday.
please.
Friday.
Thursday, because
Fine.
let us get the case diary.
Yes.
first, then I will see. Yeah. Since it must be Guwahati investigations, ACB Guwahati. Heard learned senior counsel, ensured, assisted by TR Dewey. So, let's stop. The petitioner, Amit Jain, is invoking the powers under 482 BNSS, seeking pre-arrest bail in connection with case being RC so-and-so, RC 12A25 Guwahati, arising out of FIR number and registered in other sections. The learned senior counsel fairly submits that though the petitioner is named in the FIR, but he is no significant incriminating role attributed to him. Full stop. It is also submitted that his name does not feature in the post-trap memorandum. The learned senior counsel has also drawn my attention to the order dated 6/11/2025 in BA 3469 of 25, whereby co-accused Vinod Kumar Jain has been granted bail. Also heard, Madam so-and-so, for the case diary of so-and-so, list the matter on Friday, Thursday. Thursday is okay. Thursday will be which date? 27.
27.
27. Okay.
Deep blue.
This is the second bail application for pre-arrest bail, Lordship.
Yes.
Earlier bail was rejected by Lordship. Three connected bail applications will come up tomorrow, Lordship.
Okay.
The same FIR, Lordship, where updated CD has already been called for, Lordship.
We can
We have
take it
come up
after
with
that.
this bail petition for medical grounds only. Lordship.
Whether here earlier Lordship was rejected after going to the case,
Exactly, that's true.
18/9/2025, ma'am. Whether there is any new grounds
Yes,
for
I
filing in.
I have given, I have
filing the
annexed,
second application, ma'am.
That is for, they have to show.
My lord,
And
they
they
have
have
to
to see. So anyway. but they
already
haven't-
charge sheet has been submitted, Lordship. I have a copy of the charge sheet.
So,
Tomorrow, three other matters are coming up, Lordship. This is
it is
AB 2629.
Step order, learned counsel
2633.
submits that pre-connected bail petitions are fixed tomorrow. And the
With
court
update.
was pleased to call for the updated case diary. Accordingly, this petition may be listed tomorrow along with, give me
AB
one
number-
number will do.
AB 2629/25.
AB
2629 of 20. AB.
One number will do.
Yeah, Lordship. Already listed, Lordship. Tomorrow's in cause list. Lordship.
The informal. And for.
Heard N Hawk, learned counsel for the informed. We'll hear you at the same time.
Obliged.
Kedra will hear.
Number 12.
It's a criminal petition,
Yes, my lord.
motion.
Yes. We have challenged the, my lord. This is the question of the proceeding of the CR case number 543 of so 2025, that is annexure E, page 34 to 41.
Mhm.
Here, my lord.
It was a complaint case.
Yes, my lord, complaint case. My lord, initially what happened, my lord? Here, my lord, the petitioner and the respondent, petitioner is the husband, respondent number 2, got married on 14/1/2024.
Mhm.
And after just 2 months, that is on 14/3/2024, she left
Mhm.
because she was pressurizing him to live separately because his mother was with him. So when he refused, she went away. And after that, my lord, he tried his best to bring her back, but she did not come, and she filed one complaint case, my lord. So in that complaint case, my lord, my lord,
Sridhan property.
my lord, that is, yes, my lord. That was CR case number the 765 of 24 under section 498A,
No.
389, 323, 34.
Mhm.
Then in that case, my lord, the petitioner, my lord, the statement of the, my lord, respondent 2 was also recorded, and where, my lord, the petitioner here she had challenged this CR case before this honorable court for quashing of this CR case, and by filing one criminal petition, mainly on the ground that without complying with section 154 of CRPC, my respondent number 2 has directly approached the learned magistrate under section 156(3). So on that ground, my lord, a stay was granted, so that that proceeding is has been stayed by this honorable court, and notice has been issued.
Nice.
After that, my lord, the respondent number 3 wife again filed one maintenance case that is pending, my lord. Subsequently, some settlement took place between the parties.
Mhm.
So, and they, both of them signed some documents also. I have annexed a D1 and D2, my lord. It starts from page 25, my lord.
In this, the petitioner is seeking quashing of this proceeding
The last one, the
Last
third
one,
one, third
under-
one, my lord.
under the Muslim Women's Protection of
Yes,
Rights
my
of
lord.
Marriage.
Under this, after the settlement took place,
Mhm.
again the, my lord, the respondent number 2 wife, she filed this CR case under section 318 2 296 351 23 BNS and section 3 and 4 of the Muslim Women Protection of Rights on Marriage Act 2019. So this we have challenged here, my lord.
Hmm.
And she had implicated all the family members. So
Notice has been issued?
No, my lord, this is the first time.
Oh, so first, no,
Yeah.
no. First time.
Here she is in the nature habit of my lord filing one after another cases, my lord.
Heard SB Begum, learned.
SB Chaudhary.
SB Chaudhary, sorry. SB Chaudhary, learned counsel for the petitioner. Full stop. Invoking the powers under section 528 BNSS, the petitioner is seeking quashing of CR case number. CR case, now this is 543.
543.
543 under so and so section, pending before the court of learned CJM Karimganj. Karimganj. To stop the petitioners, the petitioners are stated to be the petitioner now, number 1 is stated to be the husband of respondent number 2, and the other petitioners are relatives of the husband. Full stop. The complaint was filed by the respondent number 2, Nasima Akhtar, who stated to be the legally married wife of the petitioner. Full stop. Respondent number 1, the state is a formal party. The petitioner side shall furnish copies to the learned additional PP. Steps of notice shall also be taken upon respond number 2. You want some stay? Till the next date of listing, further proceedings in CR case number so and so shall remain stay. This is the matter after 4 weeks. This is the matter after 4 weeks. Should we fix a date or keep it open?
4 weeks because they will have. to file application.
বনজিৎ, এইখন আগতে যে এনেকে দেখা পাইছিল নি? বেছি ভাল আছে ন? 4 weeks হলে 1, 2, 3 it goes into the vacation, so let us fix it. Take a date on 18.
Yes.
18. Now gradually we'll need dates of
Minor.
26.
Start from minor.
We'll need the calendar.
Minor.
This come out, I think. I don't know. Okay,
Of like
18. Huh?
18/12.
18 December is not Sunday, Thursday. Any beleg চাইছে নি?
12.
18-12.
Not January.
18-12. 18, where you? 18-12.
Minor.
of
Will be
like
fine.
Hearing again, 35.
No, let us take the AB first.
Minor.
It will be faster.
Fine.
It will be better. We have to.
Item number 35, we have received the case.
Councils may not be, they.
That earlier rejected also, minor.
No, I'll ask them to put it in the cause list
Minor.
on Wednesday. I'll ask them to put it in the cause list.
Fine.
And I will take up the AB
Mild.
that way I think will be faster.
Minor. Minor.
We'll have to accommodate to this because our councils may not be ready
Minor.
after some time.
36.
Yes.
Lordship, can it sometime give it?
Hmm?
Even sometime, my lord.
Minor.
Time being.
In item 36, my lord,
Mhm.
we have received a case diary but not up to date, my lord. He is in interim, my lord.
Mhm.
After interim, whether he has appeared or not, his statement is not available. That's
So
it.
should we send it back?
My lord, let's him a call for up to date.
No, we'll extend the interim.
My lord.
Your good name?
A Khalek.
A Khalek, learned counsel for the petitioner. D. Sharma, learned additional PP submits that though case diary has been received, but it does not appear to be up to date. And
Statement of the.
and not clear as to whether the statement of whether the petitioner statement was recorded pursuant to grant of interim.
Fine.
Full stop. The updated case diary may be sent back, and updated case diary may be procured again.
My lord.
The interim bail by the order dated 17/10/25 shall continue till the next date of listing.
16 minus 16.
16/12.
My lord.
Okay.
Obliged,
Next
my lord.
37.
16/12.
37.
My lord, here 37 also similar prayer, my lord. Their interim was granted on 2018, my lord.
Mhm.
Interim granted, but city last entry is also, my lord. 2018, my lord.
Nice.
He appeared on 16th.
Hey, guys. Appeared on 16/11. That's why it is not available.
Same order.
Right.
Same kind of order. The interim granted to 28/10. That's extended in the next date of listing. This also, should we fix the same date?
Fine.
16/12.
My lord.
16/12.
Apply.
38.
You got no Bob.
My lord, here after that city was called for, my lord, we have not received the case diary, my lord.
Interim is there.
No, perhaps,
Well, let us keep it. He may have something to say.
my lord.
39.
Is there?
Here's 36, 17.
What section is there?
My lord,
Boroma.
31031. 3173 is
That Boroma case, right?
Boroma, my lord. 83 of 61 of 22.
And no, it's not possible to say now whether he has been charged sheeted. Not possible.
No. Only number is here. 31.
Make your, you want to say? Make your submissions.
Let's see after some time.
Otherwise, case diary is not received.
No, 36.
It is charge sheet.
Charge sheet.
Charge sheet. Okay, we'll wait. Today I'll get it. I'll লিখাই দিব লাগিব এইটো পজিটিভ
40.
প্ৰথমে এবি তাৰপিছত লিখাই দিব আপুনি কৈ দিব আমাৰ পিছত চালু কৰি দিলোঁ
Your worship.
Yes.
Sometime.
Item 40, my lord, that the updated CD was called for, my lord.
Uh-huh.
That is not received, my lord, because, my lord, the earlier it is rejected on 24th and
Yes,
2025.
I've written.
So
My
the
lord, so we
matter-
pray for it, my lord, next date. My lord, 3 years bail applications, my lord. In the meanwhile, my lord, we'll send, my lord, another communications, my lord, for updated CD, my lord.
Let us do that. Updated CD.
My
No,
lord.
sir, after some time we can take it. My senior is in another court engaged.
Up to date CD may be called.
Oh, no problem. Otherwise, we would have waited for you. Up to date CD. Let us call. As does Learned Counsel. The learned, Mr. Boyso, learned additional PP submits that though the case diary has been received, it's quite voluminous, but still, you know,
That is fully plus,
Ah.
but this one, that's not, my lord, taken back.
but
my lord. Send the
does not appear
communications.
to be updated. Therefore, the case diary may be returned back
My lord.
as paid for by the prosecution and
My lord.
procured again with the up to date, procured again after incorporating the up to date stages of investigation. Full stop. There's no interim, right?
No interim.
Anyway, wait for when do you
First week of December, any date, madam?
Any date, my lord, in the first week of December.
for
4th of December, my lord. 4th of,
April.
deeply obliged.
Applicable 54.
54. 54.
May, please, your lordship.
What timing was it?
I don't.
Yes,
Yes, sir, we pass on for time being, my lord.
not ready.
Fifty-five. 55.
আমি ওটা লোৱাৰ কাৰণে দিগদাৰ খেলি মেলি হৈছে কম পোৱা নাই অ Yes. 33.
Ma'am?
Then hearing BA 23.
Yes.
56 to give.
TCR not received.
My lord, as per official, my lord, although service complete, my lord, trial for record not received.
Service is complete.
Service complete.
Scan copy of TCR is awaited and scan complete has not been received. Wakalat Nama, you are for the informant.
My lord.
Okay, no
Oh,
problem.
yes.
Shalom. So case. He's in custody since 1880. It is from which court? I mean, no, Metro.
Metro. Tamil Metro. Metro.
The informant has, informant/respond number 2 has entered appearance to Learned Counsel. Your good name, please.
Yeah.
A.K. Hajam. However, the scan TCR as called for has not been received. It's pending for some time, so
My lord.
we should get it.
My lord.
Issue fresh requisition for the scanned TCR comprising case diary, charge sheet, and other relevant documents. So list the matter on from the court of the Learned Special Judge Pokso Kamrup M. right? That's the code.
Yes.
এনেকে থাকক, হা? I'm like, এনেকে থাকক। গৰম লাগে। So, from the court of the POCSO, list the matter. On when should we fix it? You can suggest it. from your ca-
In here, my instruction is that the LCR has already been received.
But the office note is not,
As-
office
as-
note, it's good if it's come, but it is not reflecting in the,
My lord.
2011 is the last office note. Scanned copy of TCR has not been received.
It has been numbered as session special case number 203/2025. If your lordship will reflect that number,
You can give the sessions case number. Sessions case number
session special case number 203/25.
of 2025.
আপনি মাতিলে এটা দেখুন।
Date,
Next week, your lordship.
can it be on 4th? 4th?
My lord.
4/12.
On Friday, if your lordship,
Okay. 5/12.
Friday means your lordship in this week, your
Or
lordship.
this week.
If
If it comes, I have no
my
problem,
lord.
but I don't know. It
Because
will come.
Again, we have to take time.
Why I'm saying, your lordship, the LCR has already been received. I have been instructed, your lordship. Therefore only I'm saying.
28/11.
কি মান? 20?
Friday.
28/11.
My lord.
কোনটো? আহিছে যদি দিব পাৰে।
Time being at 54.
Yes, there is special public prosecutor.
My ground is my
Yes.
medical ground.
Medical grounds.
I just want to inform one thing before your lordship,
Yes.
that your lordship, this is not the only bail application AB was rejected.
Mhm.
Another AB was rejected, which was gone to the Supreme Court against that order.
Lordship,
I just, no, one second.
No problem.
I'll just show it. That this, when AB was put to the rejection order was passed, there was some interim order, thereafter it was heard, it was rejected. They went to Supreme Court. In the meantime, when they went to Supreme Court against the order which was passed, then already this girl was taken to custody.
I see.
This girl, because of the rejection order of this court.
Oh, there was
But on
no,
the same date, when it was moved before Supreme Court said that this girl is already is 2 years old child who was suffering from fever. So immediately it should be considered and the bail application. Accordingly, on the same day, bail was granted for the other trial. This is what my lord.
My
I
lord,
just want to-
matter passing for time being, my lord, CM Vigilance Council will appear, my lord. He is coming.
can you give me
After
that?
after
Yes.
I'll keep it in the
Right.
record.
My lord, only what let him come, my lord. But my case is, my lord, he's suffering
grounds.
the
Husband
is
has to be
suffering.
taken
That's the
to Delhi.
medical, yeah, that's the only. And on the same date, my lord, the bail was granted. This is AB, your lordship will kindly say on the first sentence in the SLP in connection AB case.
Right, right. No issues.
And I have been told that the learned special court has considered and bail was granted.
Yes.
But my case is about the medical ground.
Sure. Let them come.
Yes.
No, you do it. All of a sudden.
24.
Really good. Well done, Lord.
Charged Madam Lordship,
Yes, yes.
a petitioner has been arrested on 2/6/2020 Lordship, more than 3 years Lordship, 3 years, 6 months Lordship.
Mhm.
Then there is the affair case, young Lordship. NDPS Madam Lordship, a long affair,
He was arrested on
Lordship, 2/6/2022.
2/6/2022.
Yes, Lordship, commercial continuation.
Trial must have progressed.
Yes, Lordship, 5 witnesses already examined,
Do you have any idea about how many listed witnesses are there?
13 Lordship.
1, 3,
Yes, Lordship.
5 have been examined.
I have not seen. I have annexed four numbers of witnesses, Lordship.
So we have to go into the merits, right?
Yes.
37 we have to see.
Yes, sir. A chair has come, Lordship. And is the,
After framing of charge,
Yes.
this is these are challenging laws, as you know. After framing of charge, it is always very difficult to hold in a bail that he is not guilty, right? This will be in a way quite contradictory. But again, there may be some that reigns maybe little
Lordship, after appraisal of the
prima
PW.
facie is charged, and little more than that would be the standard for bail, maybe.
Yes, Lord, after appraisal of PW's Lordship, nothing else relation, no signature is in Caesar's Lordship, kindly present the PW's Lordship. Page 47 on our Lordship.
NDPS.
I have another certificate copy, Lordship.
NDPS. Yes, where should I go? Page
Page 47 Lordship,
47.
PW1 Lordship.
Mhm.
In cross part Lordship,
Mhm.
CP is long sleeve Lordship, cross part page number 49 Lordship. Vital partnership from point 10 onwards, Lordship. I did not sign the Caesar list or Panchanama. I also did not sign the inventory. No video recording or photograph was recorded or taken at the time of the Sarsal seizure. Further, at the time of testing, suspected heroin morphine. By DD kit, no video was recorded or photograph was taken. The IO did not draw the sketch map of the place of occurrence. National Highway 15, Baidasarali after interruption of gypsy vehicle or before taking the said vehicle to Baidasarali PS. This is not a fact. Then point number 16, Lordship, I do not sign any packet of heroin, Lordship. It is not a fact. I have deposed falsely for this 18, Lordship. Today, I have not seen any seized morphine heroin in the court, Lordship. The IO before search officer did not say any notice to the accused person to respect of the searching of the gypsy vehicle of their bodies. I do not know who drove the gypsy vehicle when to the vehicle was Baidasarali to PS Guwahati. It is to call. Nothing else, me, Lordship. Then Lordship, PW2 Lordship. Next page, Lordship. The long ship, Lordship. In cross part, Lordship, page 53 onwards, Lordship.
Just a minute. Page 56.
51 Lordship, ship part,
Uh-huh.
and cross part, Lordship, 53. PW2 Lordship. CP is, I'm not reading the ship, Lordship. In cross part, Lordship, IO did not record my statement.
They were apprehended in a Naka, right?
Nakasing, during the Nakasing in a vehicle, Lordship.
Mhm.
Prisoner is the co-passenger, Lordship. Driver, I am not for the driver, Lordship. The IO did not.
Nur Muhammad Ali was a passenger.
Passenger. She is from the vehicle, Lordship. I am not for the driver, Lordship. Driver of the Indrajit Roy, Lordship. Another request. Page number 53 is finally see the cross part, Lordship. I
Then-
did not record my statements.
Hmm.
The IO did not inform me writing about the secret information. I do not know wherein the IO received the secret information. Today, I have not submitted or exhibited the offense order, office order by which we were detained for the seizure and says we stayed for 2.5 hours at the place of occurrence near the I do not know whether intelligence officer Pani Nursery draw sketch map of the place of occurrence. No search and seizure was produced to the said place of occurrence near the Kosudara LP school. I did not sign the search and seizure list or Panchanama. Thus, the seizure of other Pani Nursery prepare is charge come seizure list, but he did not separately or individually prepare search list and seizure list. I do not put my signature in any document or material exhibit. Then 54 page. I do not know whether any of our members or any other person made video recording of the seizure list. No photograph was taken, was sampled, were tested by DD kit. It is not a fact. No heroin was recovered from the gypsy vehicle. It is not a fact. I was not the NCB team on the day of occurrence. Today, I have not seen the seizure heroin in the court. Not shown by him, Lordship. There was vacant place of the problem that was the place where the was operated.
This is the first bail application, right? Before this court?
Yes, before this court. First.
Hmm.
Last one, the intelligence officer Punit Nazare did not issue any notice to the independent witness for being the standing of the independent witness of Sergeant Sejal. No whisper against me, Lordship. The Lordship PW 3 plus 55 Lordship. I've now reading that Chief Lordship. Crosspark page 56 Lordship. It will be
56.
Yes, the Crosspark. The IO did not record my statement. The OC of Bahirasaripia detailed me the two home guards whose names I have forgotten in the ambush duty along with the two battalions whose names are not known to me. The place of only Kutrupara LPA school. It is not a fact. There was a vacant place open place. Then next place 57 Lordship. Important para Lordship. And almost 25 to 30 local people gathered at the place of occurrence whose gypsy vehicle was inserted. I do not know the names of the teacher of Oshadara LP school and other two local independent witnesses. No videography was made or recorded at the time of search. Today I have not seen the recovered heroin or other materials in the court. The intelligence officer NCB did not issue any notice for me being the witness of this court. This case. It is not a fact. I was not able to hear because no historical which is this fellowship. Then also PW 4 page 15.
But I think, if I'm not mistaken, there are some, the testimony says that about their apprehension together along with the heroin, right? So,
Same line of other office of the Lordship. No signature is their Lordship. No seats produced before the court Lordship. That is the right of Lordship. Absolutely illegal detained Lordship. Then last witness examined recently Lordship. My language like maybe 4 weeks Lordship. I have compared 4 witness Lordship at the time of filing. He's a local person more than.
how was he linked to the driver? Was he an innocent traveler, co-traveler, or they were traveling together? Because as per these materials, it was found in a specially made cavity in the vehicle.
Also, they were caught red-handed, Lordship. Contraband was recovered from them, Lordship. He was the co-driver and Lordship 16.
Co-driver.
Right.
It is a gypsy vehicle, Bharati gypsy vehicle Lordship. And may not be co-driver Lordship.
They were caught red-handed, Lordship.
Have you filed any counter in this?
No, Lordship, we have not filed our application.
You can make your oral submissions. Record is here.
Sorry, sir. So he's a local person Lordship more than 3 years Lordship.
Charge sheet. Let us see the charge sheet. Or
Lordship, I will flag mark everything, Lordship. Some materials, Lordship. I will flag mark, Lordship.
now,
I will flag mark in the record, Lordship, after some time.
after some time.
I will flag mark. Lordship, I'm relying to judgment, Lordship. and the
Flag it up, then we'll take it up, and then I'll dispose it off here.
Yes.
Yeah, I can. Okay. Part hearing, that means she will flag and then we'll see. Just take 5 minutes.
Submission is short date may be given. I have submission on the bias, no?
Okay.
So on that day, I will raise it.
Okay.
On 1st of December, can it be on?
You are Mr. New, in your learned counsel for the petitioner, and your good name, please.
A day on behalf of
A day on behalf of B. Sharma, Special Public Prosecutor, Forest Department, in bracket, Wildlife Crimes. Call for the case record of offense number GPR WL, so and so. Registered from we'll call from where? From,
Forest Depot.
from the, any specific authority? Vishal?
Department of Forest Office of the Beat Officer, Bohpur, under Sunitpur East Division, Bishwanath, you know. At case number 15, you know, offense.
15.
15, offense report. Bohpur Forest Beat Office under Sunitpur East Division.
Okay, Gopur Forest Beat Office. Under Punitpur,
Sunitpur East Division.
Sunitpur Division,
East Division, you know.
East Division.
Within bracket Bishwanath, you know.
Excellent, right.
Anything on
Thank you.
112, Your Honor.
The accused, he was arrested on 15/10.
15
The
days,
accused
14
was,
days, Your Honor.
was arrested on 14 days, no, he was arrested on 15/11 or 15/10?
15, 10, Your Honor.
10.
10,
So
20,
that's, yeah, more than a month,
yes,
more than a month.
yes.
15/10/2025, presently in judicial custody. So, list the matter on, I can take it up next Monday or Friday,
Monday on 112, Your Honor. I have a
112.
submission on ground of arrest, Your Honor.
112.
112. God bless you.
Time being 35.
Yes, sir.
May it please your lordship. Your lordship, FIR is at page number 13, anticipatory bail application. On earlier occasion, CD was available, your lordship. Fixed for final hearing, your lordship.
Page 35.
Page 30. CD is at
No,
page number 1.
item 35.
13. Item 35, your lordship.
CD,
CD received, my lord.
FIR Act.
Page number 13, your lordship. May I go through the FIR?
Hmm.
With the reference to the subject cited above, the undersigned would like to forward herewith the letter received from the Additional District Commissioner Hojai, which is self-explanatory. In this regard, you are requested to lodge an FIR against the Aadhaar operator, Mr. Jairul Islam Talukdar, operator code this. The matter may be treated as urgent. Your lordship, thereafter, in page number 15 onwards, so for page number 18 onwards, is the main letter, your lordship, which was forwarded by the circle officer to the officer in charge. of-
This is the second petition?
Second
Third.
petition,
second.
madam. It was
Third.
earlier received.
Second.
Second. Some contentions are not taken.
Never
in the
mind.
first
So,
petition.
page
Page number 18, your lordship.
18.
The main letter which letter became the FIR, your lordship. Page number 18. May I read the FIR?
Yes.
Madam, with reference to the complaint from the Deputy Director UIDAI Regional Office Guwahati, dated 11 June 2025, copy enclosed, you are directed to lodge an FIR against the Aadhaar operator Mr. Jairul Islam Talukdar, operator code so, Doboka, Town Ward number 10, Hojai District, Assam. As per the said complaint, a verification and inspection was conducted by UIDAI revealed that Mr. Jairul Islam Talukdar allowed unauthorized operation of Aadhaar enrollment activities by his brother Mr. Rafiqul Islam, who used a dummy finger in a photograph of iris to temper biometric data and enroll residents fraudulently. Such actions are in gross violation of Aadhaar Enrollment and Update Regulations 2016 and guidelines issued under version 50 dated 12 March 2025, amounting to criminal misconduct, impersonation, forgery, data tampering and cheating. The said operator has been suspended for a period of 5 years with effect from 16/4/2025 to 15/4/2030 as per an instructive action taken by UIDAI. In light of the above, you are directed to lodge an FIR and initiate necessary legal action under relevant sections of the BNSS, Information Technology Act and Aadhaar Act 2016. A copy of the original complaint is enclosed, your lordship. UIDAI is enclosed herewith for your reference. This is the gist of the allegations, your lordship. Now, your lordship, may I kindly narrate some dates with regards to the incident, your lordship. Your lordship, this particular letter, which was given from the District Commissioner office to the Circle office, is dated 13th of June 2025, your lordship. On 13th June, 13/6/2025, the District Commissioner sends a letter to the Circle officer, thereby asking him to forward for registering of an FIR with 2 allegations, your lordship. What are the 2 specific allegations? Allegation number 1, that the Aadhaar operator who had the license, Jairul Islam Talukdar, his younger brother, Mr. Rafiqul Islam, was using a dummy finger and an iris print, your lordship. These are the 2 allegations, dummy finger and iris, your lordship. Now, your lordship, with regards to the, this is, first I would go through the dates, your lordship. This is on 13th of June, your lordship. Again, your lordship may kindly come to page number 26, your lordship. After 11th of June, page number 26, your lordship, 13th of June, the same district commissioner sends a show cause notice to the accused petitioner, Jairul Islam Talukdar, asking him to give a reply. And in page number 27, it is mentioned that within 3 days of receipt of the same show cause notice, your lordship. Thereafter, because he was given an opportunity of being heard to what are the allegations and what his reply are, your lordship. Your lordship, this notice came on 13th of June, and in the last annexure we have attached that at that point he was having his examination, your lordship. Thereafter, the notice said that give us a reply within 3 days, but unfortunately another 3 days passed. Within 6 days, the accused petitioner gave entire reply, your lordship. That is in page number 33, your lordship. the written explanation given by the accused petitioner before the Aadhar operator, Aadhar headquarters, Your Lordship, page number 33. This is given on 19th of June 2025, Your Lordship. First is 11th June, followed by 13th June, then again 19th June, Your Lordship. Thereafter, when 19th June was over, in this meantime, he was always having his examination, Your Lordship. We have attached the admit card of the said examination in page number 40, Your Lordship. All the dates are mentioned of the exams, and that these particular dates, 11th June, 16th June, 19th June, he was going through his examination, Your Lordship. Page number 40 is the admit card, Your Lordship, of the same accused petitioner who is also a student by profession, Your Lordship. Thereafter, Your Lordship, may I kindly come to page number 37, Your Lordship. After 19th June, when he has already given a reply to the show cause notice, the police sends a 35-3 notice via WhatsApp only, Your Lordship, not via physical delivery, via WhatsApp. That is in page number 37, Your Lordship, which means the police alleged that, that there is no necessity for arrest, but he should come and give his statement. And 35-3 notice was given, which is equivalent to 41A. In page number 37, it is mentioned, Your Lordship. After this particular notice has been received, Your Lordship, now he is apprehending arrest, Your Lordship. And then again, as anticipatory bail was filed, that anticipatory bail got rejected because this contention that he was in his examination and the contention that he has already replied to the show cause notice and everything is in written, Your Lordship. If he goes to give a statement before the police, the same statement will be reiterated, Your Lordship. We have already submitted and cooperated in all capacity with the district administration, with the circle office, and it is in written, Your Lordship. And we have annexed it before this honorable court, Your Lordship. Thereafter, Your Lordship, the only contention is that the allegation is of iris tempering, Your Lordship. That is not possible to temper an iris without the person present biologically in front of the camera, Your Lordship. The only what is the actual fact is that he started the computer, he logged in into his device, and he went to submit his course project in the college, Your Lordship. And in that meantime, within that half an hour span of time, two unidentified people came, they inspected the system and asked where is Jairul. His younger brother replied that he has gone to the college to submit his project and he will be returning in just 30 minutes, Your Lordship. That time was not given to him, and in this reply which he has filed before the district administration, he has clearly stated that there was an attempt to blackmail him with amount of 50,000 rupees, which is already mentioned in our written reply before the district administration, Your Lordship. At this stage, we cannot change even one word from our statement which we have already submitted, Your Lordship. We cannot change any narration of the incident. We cannot change anything with regards to the entire case, Your Lordship. Therefore, we are pleading, Your Lordship. And again, that 35-3 notice was given to us on this particular date via WhatsApp alone, Your Lordship. That was not physically served to me. Neither a copy was served to me, Your Lordship. This is our entire case, Your Lordship. The iris and biometric cannot be tempered. There is no aggrieved person in this entire case, Your Lordship. There is nobody who has come to say that my biometrics have been tempered.
I'll tell you, the aggrieved person, I mean, if the allegations are true, the aggrieved person is the society, the system.
Indeed, Your Lordship.
You know, so identity documents are important everywhere.
Indeed, Your Lordship.
But in this part of the country, it has an added importance for obvious reasons.
Indeed.
For obvious reasons.
Fine.
Anyway.
Here the
But
allegation
anyway,
is
of course,
with regards
it's
to login,
presumed to be innocent, of course.
Indeed.
But let us see what the investigation is.
My
It is still going on.
lord,
A
investigation
lot of time has elapsed, actually.
My lord, investigation is going on, my lord. As per my lord, although said that it was WhatsApp, my lord, 35-3 notice was given WhatsApp, my lord. Here it was given in my lord, written, my lord. Regarding the my lord involvement, I was collected materials, my lord. That's my kindly here's one second. And Lordship was pleased to reject the petition, my lord, after going to the there, my lord, highly occasional.
Some time back. You know.
My lord.
This is one.
My-
This is another matter.
35 notice of there is not complied, my lord. He's not appeared before the IO for as per my lord, direction of
This
the.
apprehension
Madam.
is
Your lordship, to that effect, the date is not mentioned.
Is this custodial interrogation required? I mean, from your point of view,
Minor.
I'll have to also make my own determination.
Minor.
But as as someone representing the investigating
Right.
agency, you may have some instructions.
Minor.
Okay.
Yeah.
So one factual part we can take from the earlier petition.
Submit
Yes, you
another
can
two
submit.
things. Your lordship may kindly come to page number 39, your lordship, of our petition, your lordship. Page number 39 of our petition, which is the 35-3 notice, your lordship. Here, your lordship will notice that in page number 39, that is the 35-3 notice, why we are claiming that it was sent to us via WhatsApp alone. On the left-hand side down bottom, it is an empty space, your lordship. Whereas the 35-3 notice which has been submitted here will have a signature of the accused petitioner, your lordship. This clearly means that we cannot get a 35-3 notice police document without giving a countersign unless and until it was delivered to us
Countersign
via
is there,
WhatsApp.
madam.
In
Jamir-
39,
Jamiruddin.
Indeed, your lordship. That has been countersigned recently, your lordship. But at the time of filing, there is no countersign in the particular document, your lordship, 35-3 notice, which was delivered to us via WhatsApp alone. your lordship.
22/6.
Indeed, your lordship. This was delivered to us via WhatsApp. There is
22/6.
no
Same date is
Same date, madam. Same date it was countersign.
on the left hand side. There is no countersign. Your lordship.
Here it is there.
Here it is there. It was done later on, your lordship. First, it was sent to us. We printed it. Moreover, your lordship, in page number 33, your lordship, may I just read two paragraphs to clarify the entire stance of the petitioner, your lordship. Page number 30.
Case the reviews, my lord, everything, my lord. That is their story, my lord.
33.
Page number 33, two paragraphs will clarify the entire situation, your lordship. Page number 33, this is the reply before even the 35-3 notice, your lordship, and which we have submitted before the ADC, your lordship. Background and clarification, blackmail attempt, your lordship. Point number 1, I have been the victim of a blackmail attempt by a man named Abdur Rauf. This is his address. This person has made deliberate false claim and is trying to extort money from me by threatening to ruin my reputation and career. Point number 1, your lordship. Point number 2, false and malicious allegation. On 9th April, when the center opened at 10:15 a.m., I went to my KKH study center at Ravindranath Tagore
I've
University
seen.
to submit the seminar project, your lordship.
Both
This
the
is-
paragraphs I've read.
These two situations unfolded, your lordship, and the only reason is custodial detention necessary, your lordship? We are humbly submitting that the situation, the statements and everything is on record, your lordship. We may be exempted from custodial detention and we are ready to cooperate, your lordship. Everything is on pen and paper, your lordship. May we kindly cooperate and participate in the investigation, your lordship.
এইটো আগৰ সেইটো পৰা লৈ ল'ব first part, no? Star. Carrot 2-3 thing like again 2-3 just 6. This is the subsequent bail application and an earlier bail petition was rejected on 4/8/2025, passed by this court in AB 1523 of 2025. The learned counsel has drawn my attention to the relevant documents annexed to the bail petition and his reply to the show cause notice which was given to him from the office of the DC Hojai. It is submitted that he is willing to cooperate with the investigation and record his statement and that his custodial detention may not be necessary. Drawing attention to Annexa 4, it is also contended that he has been subjected to blackmail and malicious allegations and vis-a-vis the present police case against him. The case diary as called for has been received along with a bail objection. The learned Mr. Sarma, the learned additional PP, submits that investigation is still in progress. The case diary has been placed before me with the relevant portions flagged. The learned additional PP has drawn my attention to the statement of one Boni Inam Sadab, a civil servant who is stated to be a nodal officer Aadhaar in the office of DC Hojai. His statement lends support to the allegations about tampering of the Aadhaar system on the part of the petitioner and his brother. I've also perused the statements of the complainant as well as other materials and witnesses. The IO has contended in the bail objection that investigation is at a crucial stage and investigation has found materials regarding the present accused person and his brother of tampering with Aadhaar biometric data. It is contended that materials have been found about the offenses being of an organized nature and investigation is on to ascertain the involvement of other persons. The learned additional PP supports the bail objections and opposes the grant of bail. Upon giving my due consideration to the matter, I am unable to find sufficient new grounds to allow this subsequent bail petition, which accordingly stands rejected. Also stands rejected. Return back the case diary.
Much obliged.
Time being 38. 38.
You ready?
Learned counsel Mr. Ayushyan is arguing the matter in foot number 500. So it means
After some.
My lord, here,
Two.
my lord, here we have not received a case there, my lord.
Okay.
Lordship may call for updated CD, my lord, at this stage, my lord.
Are you on interim?
No, perhaps no.
No,
AB matter.
interim is not there.
Update will be given, my lord.
Should we?
Pokrajar, my lord.
Okay.
From Pokrajar, my lord.
He wants to submit. Mr. Chaudhary wants to submit. Otherwise, we can because
My lord, otherwise.
if he's really submitting, let's wait for it.
Right.
Let's wait for it. Okay.
On. Time being 39.
Yes.
Page 10 is the affair. Some 399 cartoons along with a track was stolen. I am not involved. My name is not there. Now, the track has been recovered. As on 31/7, the 373 cartoons are already recovered. No injury caused to any person. Lord. Page 10 is the.
My lord, here's charge submitted, my lord.
I know.
My lord.
Quite some time back, actually.
My lord.
Page
Several,
10.
some of the persons were
All are released.
granted on regular bail.
Regular bill.
So we can ask him to, because investigation is already over, right?
My lord.
If necessary, he can They can open a supplementary and record a statement.
TCR.
Should be, is it necessary to call for the TCR? But we don't know the materials against it.
My lord, that is my lord.
But if I will appear if necessary, some protection.
Otherwise, this case was originally with serious allegations.
Yes, yes, but everything has been recovered.
Investigation is completed.
Yes.
Investigation is complete. Boroma PSR যে এইটো কৰিছিলো যে সেইটো লৈ ল'ব লাগে বস্তু। Mr. Bora, right?
Yes.
Bora Learned Counsel for the petitioner. Allegations to it. The learned additional PP, Mr. Sharma submits that in this case, investigation is, the main investigation is already completed, resulting in a charge sheet.
My lord.
In this context, the learned petitioner counsel submits that almost all the arrested persons,
Yes, yes.
all the arrested persons have already been granted regular bail by this court. Full stop. In the given facts and circumstances, the detention of this present petitioner may not be necessary, may not be essential. Accordingly, allowing this petition, it is directed that in the event of his arrest in connection with Boroma PS case number 61 of 2025, he shall be allowed to go on bail of rupees 30,000 with one surety of the like amount to the satisfaction of the arresting authority and subject to the condition that is he charge sheeted? No.
My lord, that information is also not here, my lord. It is the AD, my lord. Others are.
Yeah, that's true.
the regular bill, my lord. But
If I on a given date, I will appear before the court.
from the, my lord, Lordship, may kindly clear page 20, my lord, from the forwarding, my lord. One truck, one pickup
That's true.
truck, 20 cartons of
this-
film
let
yet
this-
to be recovered.
Since we have given, we'll not backtrack. Let this remain as interim.
My lord.
And then we call for
My
scan
lord,
copy of this.
my lord.
Call for the scan copy, case diary and charge sheet.
My lord.
However, considering the completion of investigation, of the main investigation, and the fact that most of the accused have been granted regular bail, it is directed that in the event of arrest, so and so, subject to the conditions of conditions, he shall not hamper or tamper with evidence. Number 2, he shall, should we give, ask him to record his statement?
Yes.
My lord.
Then supplementary
My
record has to be opened. He shall appear before the IO and making himself available for examination, and in the event of his statement being necessary, the IO, after taking permission from the court, shall record his statement through a supplementary record, supplementary case diary.
Within 7 days, Lordship.
10 days.
10 days. Deeply.
Within 10 days. This is the matter on
My lord, 19th.
1912.
This is 19th.
Deeply.
Time being 54.
Mr. Kotoki, you are ready.
Yes.
She is seeking, Learned Senior Counsel has not gone into merits. We
Yes.
heard it last time, last week, one question. She is seeking on health grounds of her husband, not herself, her husband.
Your lordship, in the last occasion, your lordship has also considered the hell ground, my lord. In the order, it has been reflected.
Some health grounds are considered. And some are new developments. Reports are there anyway. Just appraise the court regarding, what is stage of investigation and whether her detention is necessary for investigation.
IO has some.
Will granting bail at this stage be detrimental to investigation? Things like that, as you know.
He was called upon, my lord, but he was not available in her residence.
Mhm.
So there was a report that she is absconding, my lord, that has come.
Apprehensive. because of apprehension.
As per my information, about 1, 2, 3, 4 times I've appeared. And they have
Which-
recorded statement on
It should be available.
2/7/2025.
Should be available in the case diary.
8/7, 18/7 and 28/7/2025.
Mhm.
I cooperate with the investigating agency, man.
Hmm.
They want certain document I sought for some time.
Mhm.
So that's what my information is, man. It's
And-
not.
Legal my lord, actually she is still suffering from, I think.
Not her, I think.
The husband, my lord.
Husband. He's a patient of prostate cancer.
That's
No
okay,
doubt about it.
but,
That is,
prostate.
that is clear.
And he was discharged from, I think, from MK hospital.
Yeah.
around month of
Anyway, I can see the up-to-date investigation.
Yeah,
You can pass order.
Yes.
Chamber, some, I'll go through it. Yeah, in lunch break and pass break or after. You, any submissions? No?
This is what
Ah.
Physical or medical grounds he is in.
I'll pass the order.
And
Chamber-
I think my learned friend appeared in the trial court. One of the accused also has been granted bail on the direction passed by Supreme Court.
Supreme Court has,
Supreme, I have given that order.
we have got it.
Yes.
I've kept that order in the file.
That was at the time AB was moved. But in the meantime,
Yes.
we were taken to custody.
Yes, yes.
Say if the court.
So regular bail was
granted.
granted.
Regularly, on the same day the bail was granted.
Yes, yes.
Not same day, after remand, my lord. There was,
Whatever.
After,
after 1 day remand, my lord,
One day only.
because there was a 2-year child, man, not on the ground.
That's an held grounded silence.
special grounds.
Sorry.
These are
Here also I am
Special
seeking
grounds.
for a special ground. Deeply obliged.
Next.
Time being 55.
May I please, your lordship?
Chaudhary.
Lordship, on the last occasion, my lord, PP was directed to
Oh,
obtain
yeah.
the instruction
Mhm.
whether, my lord, notice
35.
under section 35 was issued or not, my lord. Here, my lord, offense is under section 74, my lord, where punishment is up to 5 years.
Silence.
And my instruction, my lord, that there was no notice was served to you, my lord. On that
Oh.
ground only, my lord, I
No,
submitted on the last occasion,
Mm.
my lord. And learned PP was directed to, my lord, obtain the instruction whether 35 notice was issued or not.
Lordship, we have got the instruction, Lordship.
His diary was also called for. Not called for.
Was up.
Oh.
Regarding the issuance of notice under section 35(3) of BNS.
It was not served, they've admitted. Not served. But,
Lordship, can you go through the reasons?
mm,
35, Lordship 1, subsection 1.
the police officer, let us, we have to refresh ourselves again and again. These
Lot.
Bayer Act provisions.
Yes.
Subsection 3, let us read again.
Yes.
Police officers are in all cases where arrest is not required under section, not required, which
Yes.
is under subsection 1. That means,
When police may arrest without warrant, Lordship. Subsection 1,
35(3).
35.
it will cover an offense up to 7 years?
Yes, my lord.
Mhm.
Our case, my lord, 74 is the non-bailable.
5 years.
5 years.
So if you are notice directing the person against whom a reasonable complaint has been, credible information has been received. Are they saying that his arrest, this is not applicable? Are they trying to say that? 35(3) is not applicable? Not saying that.
See,
Yeah.
35(3) is not given because Lordship, the reasons is given in the report.
Mhm.
Why not? Then it may come under section 35(1) also.
No, they're saying that it comes under 35(1), the section.
It might come, Lordship.
Just a minute, no, it's just come true.
35(1). One consent, one sin.
Okay. Otherwise, what is the offense?
Women with.
Where 14 is the other, madam.
To face no modesty, Lordship. Section 74 of the annex.
We'll get the case diary, ask him to record his statement. Okay. Heard BM Chaudhary. 21, and learn it, additional PP, SH for the, as I heard stated, oh, or you can take this second paragraph, last order. Let's stop. The FIR is dated 23/10/2025, lodged by one Susmita Rao with the allegation that on the previous night at around 10 p.m., when her husband was not at home, the accused, he's Bijoy Tati, right?
Yes,
Vidut Tati, who's their neighbor, came inside the house and harassed her. And when she made hue and cry, when she raised hue and cry, he assaulted her. Full stop. Why is this mentioning about date of incident is
Yesterday, it is.
mentioned as yesterday. The learned counsel for the petitioner on earlier occasion had contended that as per his instruction, had fairly submitted that as per his instruction, notice under 35(3) BNSS was not given. To this, the learned prosecution was directed to take instructions, full stop, pursuant thereof. A report dated 23/11/25 has been placed before this court, where the investigating officer has fairly stated that notice under 35(3) BNSS was not served. In the said report, the IO has also stated the reasons for such non-service, which are mentioned as that ... It would hampering of lawful process of arrest, semicolon, grave offense, etc. Do hide you over, you can raise stuff. Nevertheless, I deem it fit to peruse the case diary for proper adjudication of the bail. Accordingly, call for the case diary of Morioni PS case 152 of 25. However, in the interim, 20,000 with one security to the satisfaction. Cooperative investigation appear before the IO for recording is stated. This report will be kept in the record, right?
Lordship, that may be.
You can give a date convenient to both sides.
18/12 of.
Okay, 18/12.
Obliged, Lordship.
18/12. Time being. Time being.
25.
It is a lordship. So this is a charge sheeted matter, my lord.
Mhm.
Charge sheeted under section, my lord, 10 of the POCSO Act.
Right.
10. My lord will find the FIR at page number 16.
Give me a chance to read the, I'll read the FIR. I'll just read it myself.
My lord.
Just give me 2 minutes. Allegations against. He's stated to be the stepfather.
Therefore, I.
Okay, she was
request-
appointed MLA.
Yes, therefore I'll request to, since Lordship has already heard the matter, Lordship, if Lordship is time permits, if it can be taken up today, Lordship, I've also informed the public prosecutor
Okay, today only?
today.
Okay, I'll take it up. Today you can appear. Okay, tomorrow, from tomorrow you'll be on leave. Oh, no problem.
Deeply obliged.
After some time?
Yes.
After some time.
24. 24. 25. 25.
25. My lord, that matter, my lord.
Yes.
I'm sorry, I was on election court. My lord, a status report was called for. Two PW's prosecution witnesses are examined, my lord.
You are for the, you are.
Yes, my case, my lord.
D. Gogoi.
My lord. If lordship peruses the informant and the victim has been examined. Well, nothing. Informant and victim are crucial. They have been examined.
Yes, yes.
Only on that ground. Kita sih. Total 11.
Depositions are available.
Yes. Not in the record, not there.
It's not available.
Only that.
You have certified.
I have the certificate copy.
No, available.
Informant already. મારે દેખી છે બહાર પહેરતી એસી બહુ જંગલ ના પતા નહીં શું બને
There's some implication.
Yes. I'm not subject married deaths, my madam.
That's okay. Examine, so very young girl, 10 years.
Yes, yes.
It's okay. I'm granting bail
Mine.
because they have been examined.
Yes.
But there is some, very young girl, 10 years only.
10 years, 10 years.
Heard as thus learned counsel for the petitioner, additional PP and Sharma, and D. Gogoi learned amicus for respond number 2/informant. The present accused is facing trial in special POCSO case number 225 of 2025, which arose out of Rupohiyat PS case number 195 of 2025 under so sections. Full stop. The scanned copy of the TCR as called for has also already been received. The accused was arrested on 15/6/2025 and since then is in under trial detention. Full stop. The learned counsel submits that as part of the trial, the informant and the victim have already been examined, and in support of the said submission, the said contention submits certified copies of the depositions of the informant and the victim girl. I have perused the same. Full stop. The learned additional PP submits that the trial is not yet complete, though there is no dispute that the informant and the victim have been examined. Mr. Gogoi learned amicus also submits that necessary orders may be passed as per law, and he does not dispute the examination of the victim and the informant. Considering the progress of investigation and the length of under trial detention, I deem it fit to grant bail to the accused at this stage accordingly. is allowed to go on bail. How much should I, 30,000 or more than that? 30,000 with one security of the like amount to the satisfaction of the concerned learned court, which is
Special justice here just Pokso no.
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 Oh, and subject to the conditions that now he shall be available for remaining trial, not hamper or temporary dividends. He shall not intimidate, harass, or cause any harm to the victim and her family. Violation of bail conditions. The bail petition stands allowed and disposed of. This you can take back.
My lord. Highly requested.
Right.
24.
4. Ulma, so this one.
I have flag mark related.
Like mark?
And Lordship, your Lordship, contraband recovered from his possession, Lordship, they were caught.
Red-handed too.
Red-handed, Lordship. Sufficient materials are there, Lordship. And I have submitted to judgment, Lordship.
Yes.
Lordship may consider.
Namdeo should be.
Namdeo and Varghese, Lordship.
Viewed at the issue of extension.
Lordship, consider the detention period under the trial, Lordship, more than 3 years or 3 years, 6 months, Lordship.
No, that is true, but you know that the for considering that it's a commercial quantity, the hurdle of 37 has to be passed, and it's a very tough hurdle, especially when charge sheet is filed, especially when you know charge is framed. Very tough hurdle. As I said, no, how do you say after framing of charge that person is not guilty?
Yes.
It's only a difference of degree. It's only a difference of degree.
Yes, then today 5 numbers of witnesses have already examined.
Yes, yes.
Out of 13.
Otherwise, in a normal bail application, that is not a problem. It's a very good, you know, situation in your favor. Otherwise,
So we need to look at from Barbara district.
let the investigation be completed. Sorry, let the trial be expedited. That's all we can say. I think it's not possible to hold that it's not guilty. Witnesses are coming. Witnesses are coming. It is a mandate also in one of the judgments also, I think Thana Singh or something. I mean, said also, commercial quantity matters have to be expedited. Because usually the people don't get bail. The heard Hamid Learned Council and Deka, Learned Standing Council for the NCB. No, it's okay. 483 bail application. Nur Muhammad Ali in connection with NDPS case number 34 of 2022 under 21C/29 of the NDPS Act, which arose out of NCB crime number 14 of 22. The trial is pending before the learned special judge Rongya Kamrup. The accused was arrested on 2/6/2022 and presented quite a long time, but that's the thing. Should be completed. The allegation in the FIR is about recovery of a commercial quantity of contraband in the nature of heroin or morphine, heroin from a vehicle AS01 FA 4617. In which the present petitioner and another co-accused were traveling. The learned counsel for the petitioner mainly contends that he has been in under trial detention for a considerable period, and though trial has proceeded, but only 4 witnesses. 5 witnesses have been examined out of the listed. How many witnesses list? 13 witnesses. Full stop. It is submitted that he shall abide by any conditions imposed if granted bail. Full stop. Considering the fact that the penal provision of NDPS Act pertaining to commercial quantity is involved within bracket 21C. Therefore, the applicability or otherwise of the provisions of section 37 of the Act has to be seen, especially when the prosecution has opposed the bail. Full stop. it is well settled that wherever the rigors of wherever the rigors of section 37 of the Act is applicable, the court the court shall be able to grant bail to the accused only upon a determination on the basis of the materials that on the basis of the materials that the accused is not guilty prima facie. In this regard, the learned counsel for the prosecution submits that the accused persons were caught red-handed, and their seizure was also supported by witnesses. Full stop. The investigation resulted in a charge sheet, and the learned court below was also pleased to frame charges against the accused person, including under 21C. What is this judgment saying, Mr. Eka? On which point?
See, Varghese Lordship, from para 13, Lordship. Delay cannot be the ground granting bail, Lordship.
No, now there are some judgments. You please, you can do research, it will help all of us. Now there are some judgments where the interplay of 37 and provisions like that, 43DP and 21 has been, has been gone into. There are some recent decisions. Najib is slightly older, right? It was after COVID, 21, I think. But there are some recent decisions, so for guidance. But at this stage, even more, if they are suppose 7 years in custody and no trial, then probably it will prevail over. But this is also considerable time, but still, I think we'll have to go by 37. This law is also evolving, actually. At what point of time exactly? It cannot be calculated by mathematical precision. We want, and as students of law, we want that. What is the trigger point where Article 21 is prevailing everywhere? All of us, at all stages is prevailing. But what is the trigger point where Article 21 will gain upper hand over these statutory restrictions? That is the point, Like Vihan Kumar, it has been clearly said that irrespective of any statutory restrictions, if this is violative of fund, it will prevail. So similarly, here, the trigger point cannot be measured, cannot be fixated. That 3 years, 4 years, it cannot be fixated. It depends. So we have to find at what point it is triggered. That law is evolving. So we need to do some research and find the recent decisions. But this is, of course, one point of view. This is also a recent decision, 7, very recent decision. And again, you might find divergence of opinions also between different benches of Apex Court. One is taking a little liberal view in favor of constitutional provisions. One is taking this view in favor of statutory restrictions. Anyway, delay time. The learned prosecution has placed before this court judgment/order of the Honorable Apex Court in the case of Union of India versus Namdeo Assam, and drawn attention to para 12, 11, 12, and 13. I perused the said case laws. The said paras may be reproduced herein below, from the soft copy. Upon considering the submissions of the learned prosecution and perusing the materials available at this stage, full stop. This court is unable to come to the opinion that the test of section 37 NDPS Act is passed in favor of the accused. Consequently, the statutory bar on grant of bail envisaged under section 37 of the Act with regard to commercial quantity continues to prevail. Full stop. Therefore, the bail petition is hereby stands rejected at this stage. However, the learned trial court is requested to endeavor to expedite and complete the remaining trial, considering the under trial detention of the accused. The other person is also in jail.
Highly obliged.
Time being 38 আছে নাকি? 38.
Come.
In this case, Lordship, up to date, there was one for Malad that was not received, but short date may be given.
Not received.
My lord, CD not received, my lord. Up to date CD was called for, my lord.
Okay. Case diary, up to date case diary is called for not yet received, issue fresh requisition. List a matter on. Date to.
This is the third time, my lord, city was called for Malad.
9th, my lord.
The prosecution shall take steps to do the needful so that the diary is available on the next date. You take, give him instruction.
9, 9.
9, 12?
9th.
Okay,
9 to 12, I was not interim, my lord, so.
you don't have interim. You want it earlier?
Earlier, my lord.
Give him an earlier date. 4 or
5th, my lord. 5th, my lord. We'll try, my lord. 5th.
29.
Lordship, this is a search sheet case, Lordship. Lordship, search sheet has been filed on the 25/6/2025. And the Lordship, in this case, Lordship, the main accused is Sirajul Islam. And the Lordship kindly peruse the FIR page number 12, Lordship. Lordship, in this case, 14/2/2005, the police visited in the house of the Sirajul Islam. And the Lordship, before police reaching in his house, Sirajul Islam fled away. And the Lordship, in absence of Sirajul Islam, his wife, the Anjuma Begum, the present petitioner, and his minor, the son, the Akhtar Hussain, who is aged about 16 years old, was arrested by the police. And the Lordship, when the police searched in her house, from the storage room, where 24 kilograms of ganja was recovered. And the Lordship, the police filed the search sheet 25/6/2025. Now, Lordship, I am behind the bar of 9 months and 293 days. And the Lordship, in this case, my husband kept the contraband in the storeroom, which was not in my knowledge, the Lordship. And the Lordship.
Still the wife?
Yes, Lordship.
Anjuma Begum, Akhtar Hussain.
Yes,
Both are accused, right?
Yes, Lordship.
Including the wife, husband. 2 persons apprehended, including the wife and the son, the main accused. And the accused number, that is on Sirajul Haq. He is absconding, he's still at large, is evading police arrest option.
It has just been charge sheeted, right?
It's just been solicited.
25/6/2025 patent has been filed.
Now the case.
And the Lordship accused Sirajul Islam is yet to be arrested by the police. And the Lordship search has not been framed. And the Lordship, I am
the stage of production stage.
Yes, Lordship.
You have to help me, determine that there are materials to indicate that she is not guilty, right?
Not sure.
Yes, Lordship.
So
37.
otherwise, section 37
Yes, Lordship.
will bind us all,
Yes.
you know.
But Lordship, I am the wife of the main accused Sirajul Islam. He has kept the contraband in the storage room. And with the contraband was recovered from the storage room, not from the bedroom, Lordship, not from the kitchen room.
Right. So let us see the narration in the charge sheet only.
Yes, Lordship.
Yes,
We'll
in
get it
in the
at page-
petition also it is there.
Page
but you can see
21 on.
from the petition.
Yes.
Case diary has been received along with this
No, so it's a
report.
solicited matter,
Yeah,
Lordship.
yeah.
And scan copy call for that we have received.
Scan
Yes,
CD.
TCR.
Lordship, it is search sheet.
Does it include the case diary also?
Lordship.
Because it is, that's why I mentioned, it is very essential. Otherwise, 37 determination requires CD and
Lordship.
CS. both.
Come on, Devu.
maybe there, but parts of it, whole may not be, doesn't likely.
Recipient
Doesn't look
page
like.
23 of.
Mhm. Because we have to see the complete picture. It's a very stringent provision. Okay. Shall we read the narration in the charge sheet? 14.2. Available source information. Conducted a search operation.
Thank you, Lordship.
Absconder charge sheet was.
Yes, Lordship. It was recovered from the dwelling house of the.
Case diary is there. It is there. I'll have a look.
But in the search sheet, it is mentioned that I could not explain how the contraband was in my house.
Very difficult sometimes to segregate.
Lordship, I was arrested.
Very difficult to segregate actually, you know. Very difficult. Conscious possession of A or B, you know, it is only becomes clear at the stage of trial.
Charges are yet to be.
Even
framed.
there may be mistakes if you are not careful.
Yes.
But Lordship, there is no other criminal case against me except this case, Lordship.
Admittedly, Lordship, kindly go through the statement of the accused.
Mhm.
And on a credible secret information, the police conducted search at the house of the physician and recovered, Lordship, 24.810 kg of ganja, which is commercial quantity.
Independent witnesses are there.
Since the witnesses of it.
Mm. Khan has also been
Yes.
as a
Lordship.
CCL.
Yes.
No, only 8 witnesses actually.
Charges are yet to be framed.
Hmm.
First.
Lordship, I want to submit a judgment, Lordship.
Yes,
for
please do.
the Supreme Court, Lordship.
Sure.
Where 21 kilogram ganja was recovered
Yes,
and the
please.
bail was.
Supreme Court always has this plenary power, which is like an amazing power, of course. But
But Lordship,
otherwise,
I'm the wife of the
see.
the main accused person. And my husband dealing with the contraband, Lordship. So I had no knowledge. And the lordship, in absence of my husband, I was arrested. And I was brought to the police station. And I was pressurized to produce my husband before the police. When I was unable, lordship, then I was arrested. Lordship, in the judgment, the Honorable Supreme Court is going for the merit of the case, the bail was granted, lordship. And the lordship, 24 kilogram ganja.
Since the recovered these articles, Lordship,
The lordship, in this
Is
case,
covered
when
in
police will arrest the Sirajul Islam,
Embargo
when the
will
search will be framed, the trial will be delayed, lordship.
the court has to record his satisfaction, Lordship.
Mm.
The
We
present petitioner
till-
is not guilty of.
Yes. Till the High Court, this is compulsory.
Yeah.
As I said, if you read this order, though it has not been, there's no reference to 37 and also Article 21. So it appears to be, in a way, exercise of plenary jurisdiction on 42. So they have all the powers in that jurisdiction. So can you have a look? You can have a look at the judgment. You can have a look. Short order. Length of detention has been considered. Just prosecutor. These are witnesses.
One of the main accused is, he's still at large,
Yes.
still at Scotland. So under the modus operandi of the entire,
Lordship, trial will be delayed, lordship, if he is not arrested. And the
It has to
lordship,
be
I am already behind the bar of
It
9
has to be
months.
split then. It has to be. It cannot continue indefinitely if she is not granted bail. It has to be split. And it can be fast track. 4 weeks they can complete theoretically. 2 weeks, 2 witnesses every week.
it is on consideration the period of incarceration. Lordship.
Mm.
And there are,
So either it is 21 or 142.
there are 10 accused persons. Lordship.
Mm.
Here it is.
What is the
recovered-
length of incarceration in this case?
His Lordship, the petitioner is in custody with effect from 57/2024,
About a year.
and which that is not,
Lordship, more than 1 year, lordship.
it's not given very
That's
clearly.
why I thought that it's
Clearly.
plenary jurisdiction,
Yeah.
exercise of plenary jurisdiction.
Specific.
But lordship, in my case, my son was also arrested by the police.
Yes.
Because lordship, he was minor. And he was not dealing with the contraband. But lordship, he was arrested by the police. Why, lordship? Because the police could not arrest the main accused person, so I was arrested along with my son.
They have supported, otherwise it will be difficult to say that she is not, because see, the thing is that once you see, foundational fact is that from the premises which is shared by A and B, so and so contraband is recovered, okay? That foundational fact gets proved, suppose that.
Yes.
And thereafter the burden shifts to you by preponderance of probability that it is not my conscious possession. I am not conscious possession. So that would require evidence, but at this stage, evidence is not started.
It was stated there, the contraband was recovered from the storage room, lordship.
Mhm.
Stage of bail,
Mhm.
the bail. So it is sufficient.
If she was suppose temporary, guest or something, then of course that can be, that can be an important factor, that angle. But since the accused is also a regular inhabitant of that house, so prima facie, the burden shifts to her. Prima facie, since recovery is there, Yes, it can happen that a close family member may not, it's possible in the, it's a possible thing by
in
human
the-
behavior that a person may not know or may know. But once it is recovered, that prosecution has proved that foundational factor.
But
And
Lordship, first of all,
I have to show that I was not aware, though it's in my house.
But Lordship, contraband was recovered from the storage room, not from the bedroom, Lordship. Because it was the storage room.
From the bedroom now.
She has stated in her statement that she knows about that
Yes.
he doesn't, that's not admissible, but that she knows about that he traffics in drugs, but she does not know from where she gets. So her statement indicates that she does not know, but her statement is not admissible
Yes.
either way.
Her testimony is required, Lordship. This is a relevant witness. Lord.
There are only 8 witnesses anyway. 37 to 31. Huh? Heard so. Mr. Deori for learned counsel for the SH for the learned additional people for the state. The petitioner Anjuma Begum is seeking regular bail under 483 BNSS in connection with NDPS case number 138 of 2025, arising out of Rupohiat PS case number 57 of 25 under section so and so sections. The case after the case has been charged sheeted and is poised for commencement of trial before the court of the learned session judge Nagaon, before the court of the learned additional session judge number 3 Nagaon. Full stop. The scan record is available. After investigation, the case was charged sheeted against the present petitioner and her husband under section what are the exact sections?
Under section
20C/25 29 of the NDPS Act. The allegation is about recovery of commercial quantity of suspected ganja from the house premises of the accused petitioner herein and her husband, who has been shown as an absconder in the charge sheet. The alleged quantity is 24.810 kgs of ganja. Full stop. The learned counsel strenuously submitted that she, as the wife of the co-accused, is not aware of any storage of suspected drugs in her house. It is submitted that the accused is in under trial detention since 15/2/2025 when she was arrested in this case. The scan record has been received and perused the relevant portions thereof. The learned additional PP, Mrs. Bora, submits that the co-accused, who is the husband of the petitioner, is still at large and there are sufficient materials against the present petitioner also. I have perused the narration in the charge sheet. Full stop. The seizure witnesses have supported the seizure of the contraband from the premises of the accused petitioner and her husband. Full stop. On the basis of the available materials at this stage, it is not possible to hold that there are no reasonable grounds to opine that the petitioner is not guilty of the alleged offences. Thus, the test of section 37 NDPS Act is not passed in favor of the accused. And consequently, the statutory bar envisaged by that said provision in granting bail prevails. Stop. Accordingly, the instant bail petition stands rejected at this stage. In the event of framing of charge, the learned trial court is requested to endeavor to expeditiously complete the trial, as the number of listed witnesses is only 8. Full stop. Further, it will, nothing stated in this bail order should be taken as expressing any opinion on the merits of the case to the prejudice of either the accused or to either the defense or the prosecution. It is necessary. This kind of determination. Okay. Next.
27, time being.
Oh. 27. This is child marriage.
95 days already in custody. Otherwise, look at they have gone to.
There's a Jhanni Munda and others, Housey and all. Thereafter, what has happened? The police has come, Organizer is a different. Police has come. Everybody has fled away, including the petitioners also. Here, they are the employees of Oil India. Now, one of the person who fled away, he has fallen down in a pit and he died. Kindly see, Lord, we are behind the bar, Lord. Because what has happened, we are present at that point of time. So, Lordship, kindly see the FIR which has been lodged by the wife of the deceased, my Lord.
Yes.
And your Lordship, my Lord, what she stated, my Lord, your Lordship will find at page 10 of my petition,
Yes,
my Lord.
I am on 10.
My Lord. That is a translated copy. If your Lordship want to see the vernacular.
Whichever you prefer.
If you Lordship wants to see the vernaculars is all there, my Lord. My Lord, whichever your Lordship likes to. The vernaculars, my Lord, will be clear that Binommo Bhabe Janao je, moi Srimoti, Paru Setri Duliajono Subhas Polio, Elekar Nibaki Sirijut Roghiu Rador, Omokova Habiti, Bakihot Bodinor Pra, A Dampoti, Mul Ayujok, Ayujok, Sirijut, Monulhor, we are not, my Lord. My Lord, I'll just say Binom Bhabe Janao je, moi Sri Paru Setri Duliajono Subhas Poli Complex or Nibaki, Sri Raghuvi Yadav, we are not Raghuvi Yadav, Aru Srimoti Habiti Javar Bahagyot, Bohudina Pra, A Dampoti Mul Ayujok, Srijut Monu Sahar Hote Mili, Jua Kedin Manapra, Bor Dangor Koe, Jua Khel Ayojon Kori Asil, তেওঁলোকে নিজৰ চিনাকি বিলাকক মোবাইলৰ যোগেদি ব্যক্তিভাৱে ঘৰে ঘৰে গৈ জুৱা খেলাৰ বাবে উচতায় জুৱা 19-10-25 তাৰিখে মোৰ স্বামী শ্ৰী সৰ্পবৰ্ধন ছেত্ৰীকো বাৰে বাৰে মাতি আনি ফুচলাই দীপাৱলী দুহাই দি ঘৰলে মাতে আনি প্ৰসাদ খোৱাৰ কথা কয় সেইখিনি সময়তে তেওঁলোকক আৰক্ষী আহিব বুলি ভয় খয় মোৰ স্বামীৰ হৈতে আৰু কেবাজনো অজ্ঞাত ৰাস্তাৰে বিপদসংকুল পথেৰে জানি বুজি পলাবলৈ কয় এই সময়ত পলাই হাৰুতে পিটনি এটা পৰাৰ পাছত তেওঁৰ মৃতদেহ ইমান তাৰিখে উদ্ধাৰ হয় হে অনুগ্ৰহ কৰি this is the FIR Milord. Admittedly, Milord, that is where the police has registered a case under section 105, Milord, not amounting to murder, Milord. The punishment is 5 to 10 years, Milord. Now, your Lordship will find the forwarding report, Milord. In forwarding report, the police has mainly said that these are the organizers
of the gambling.
Of the gambling are the main culprit, Milord. And so far we are concerned, Milord, there's nothing, not a single word against us, Milord. In the trial, Milord, in a subordinate court also, while we move the bail applications, Milord, your Lordship will find they have filed a bail objection, not against us, Milord, against all the three, Milord. Your Lordship, kindly see, this is the objection filed by the IO. Kindly,
and this petitioner's name is?
They are, my Lord.
Shekhar Gogoi.
Well, there one is, my Lord, Deep Shekhar Gogoi. One is Hemsaran Bora, alias Hemsaran Bora. And one is Navdit Sunal. These are employees of Oil India, my Lord. Oil India, sir. Well, so far we are concerned, my lord. Well, the bail objection, what the lordship will find, I kindly see, against us, nothing has been written. Only I just mark this, I underline. We have been interrogated, we have been put under suspension. Well, our job is at stake, my lord, because we are present at the site, my lord. Definitely, my lord, during the eve of, my lord, we also go for Housian who organize, my lord. Now, police comes, my lord, and police has, my lord, they fled away. One person, the fall in the pit, my lord. And how we are involved, my lord, I don't know, my lord. My lord,
For the murder, this homicide, the linkage may be a little weak. Linkage will be, anyway, what is the prosecution?
Also appearing for one of the
Ah.
employee only.
Okay.
Direct, there is no involvement. Initially, police arrested us. We are now under suspension. Local people, all we have children, married, our wives and all are also working. So, your lordship will kindly consider. Because further custodial detention may not be necessary at this stage.
Well, so far the organizers are concerned, my lord, we do not have to say anything, my lord. The police also
Some
has.
Shah, no?
These are not, my lord.
His wife, Sabitri, some.
My lord, they are the
brother,
person,
Raghubir,
my
some.
lord. They are the person, my lord. They are the person who organizing, my lord. They are the public, in the field, my lord, they are organizing. We have just come, my lord. So that is why the IO has given an objection to them also, not for us, my lord. And we became a victim as we are present at that point of, my lord, occurrence, my lord.
His dead body was found a good 10 days after the.
Yes, my
Yes,
lord. Here, my lord, that is the date of incident was, my lord, that is 19/10/2025, my lord. And my lord, body recovered on 26/10/2025, my lord. And thereafter, FIR
8
is
days.
lodged on, my lord, 28/10/25, my lord. By the deceased wife, my lord. Now, my lord, in item number, my lord, 31, my lord, there are 3 numbers of, my lord, accused petitioners. One is Deep Sekhar Gogoi, another one is, my lord, as stated my learned senior, that is Hemsaran Bora, and third one is Nobodip Sonoal, my lord.
Right.
Now, my lord, police during the course of investigation, my lord, they, my lord, in the meanwhile, file one, my lord, that is, my lord, there is the objection prayer also, my lord. That is also enclosed, my lord. There, my all these fees are not there, the FIR name accused. But, my lord, against, my lord, Nobodip Sonoal, my lord, they, my lord, file one objection, my lord. Otherwise, race part, I have already flag marked, my lord. And my lord, in my lord, that is in item number, my lord, that is 6, my lord, production list, my lord, not 6, my lord, production list 1, my lord. Just tomorrow also it is in 6, my lord. So that is also 1, my lord, Pulok Hajorika, my lord. So that is Pulok Hajorika is also, my lord, in the same line, in the like Deep Sekhar Gogoi and all. All are, my lord, arrested on 1/11, my lord. And my lord, during the course of investigation, my lord, it is found that they were present, my lord. Now, in the matter, my lord, that is item number 49. So it is against, my lord, all are, my lord, all 3 are FIR name, my lord. Manoj Prasad Shah, they are in the, it is Manoj Shah, like this way, my lord, it is stated. And my lord, another is, my lord, that is Raghubir Yadav, and another one is, my lord, Sabitri Devi. So they are before your lordship, my lord. And rest part, my lord, in the FIR, they are FIR name accused because they were stated as an organizer of the, my lord, that is gambling. And my lord, may kindly peruse the CD relevant part already I have flag marked, my lord. All are arrested on, my lord, 1/11/2025, my lord.
11?
1/11, my lord. 1/11.
1/11.
1/11/25. Today is, my lord, that is
24 days.
In some of the accused in the Games and Betting Act have already been granted bail.
Yes.
This was only in this second case. We are
Games and Betting Act is punishable up to
3 years.
3 years.
Yes.
But the act has made it all cognizable and
non-bailable.
non-bailable.
Yes. Now it is non-bailable.
so far my junior friends clients are concerned, they are the organizer, but I don't think that they are also involved in the killing. But
Okay,
they are the organizers.
OD may be responsible for that.
Yes, yes.
As of now, prima facie.
Yes.
It's an unfortunate circumstances,
Yes.
but for the
Yes, Milord, these are very
betting, yes, that will.
PM report, my lord, that is available, but my lord, that is the Visara, my lord, steel, my lord, chemical analysis report yet to be collected, my lord. That is awaited.
Similar ধৰণৰ order হ'ব অলপ বেলেগ হ'ব। So this hearing I have to take it slightly separately, this one.
31. For the, which one, Milord?
The Manoj Prasad Shah.
Oh, no. That is,
That has to be
separately.
separately. I do have the second paragraph or first two paragraphs in last order. It's okay. এইটো আমাৰ হেৰি I think 31 BA 3696 of 25. No, last order, first two paragraphs same. Buni the case arose out of FIR dated 28/10/2025, lodged by Paro Chetri, wife of the deceased, Hark Bahadur Chetri. The gist of the allegations is that Raghubir Jadhav, along with Savitri Jadhav and Monu Shah, SH, have been organizing gambling at their house for a long time and encourage people to participate by calling them on their mobiles. Full stop. That comma on 19/10/2025, her husband was also invited for such gambling on the eve of Diwali. But after going there, he was frightened that police may come, and accordingly thereupon while running away through a road, he fell down into a pit and his dead body was recovered on 26/10/2025. Stop. Mr. Bora, learned senior counsel, submits that it's an unfortunate incident, but the present petitioners are nowhere connected with the death of the informant's husband. And they were arrested on 1/11/2025. And they have also been examined, custodially examined. And it is prayed that they may be granted bail at this stage. Stop. The case diary as called for has been received. There's bail objection against all of them.
All of them, my lord, they categorically, my lord, stated against, my lord, one that is this Navadip Sonowal, my lord, that is in, my lord, present 31, my lord.
It was organized by these three, but later on in their house he came.
Yes,
Navadip
yes.
Sonowal.
Yes.
Full stop. I perused the bail objections submitted by the Ayog. He has reiterated that the gambling was organized by in the house of Raghubir Jadhav and his wife Savitri, along with accused person Manoj Shah. So, it is also stated that later Navadip Sonowal, Hasmat Ali and others also came for the gambling. And what else should I see? It's a Upon perusing the case diary, I find that there has been progress in the investigation, but the same is not completed. Anyway, let them go. Seeing the progress of investigation and length of detention, I'm of the considered view that perhaps the accused persons, petitioners herein, namely so and so, can be granted bail. Accordingly, they are allowed to go on bail of rupees 25,000 each, with the surety of the like amount each, with the satisfaction of the concerned learned court, CJM Dibrugarh, and subject to the conditions that number one, they shall cooperate with remaining investigation, shall not hamper or temporary evidence. Number three, they shall not misuse their liberty to commit any illegal activities, including any activities prohibited by the Assam Games and Betting Act 1970. Violation of the bail conditions would make their bail liable to be cancelled. Stop. Return back the case diary. This is one. The other one is
I'm obliged.
Pulok Hazarika is
I'm agreeing, my lord. He is also an employee of the Oil India.
similar. Pulok Hazarika alone or
Hello. He is also an employee of the Oil India.
same arrested or
Same
same
thing, only the name will be different.
different?
And the council name will also be.
Council name, of course, not senior council, BD board. Conditions, everything will be same, right? 25,000 with 1 This matter needs some hearing, and the prosecution also, we may have to submit. Will it be justified to grant them bail also?
This, my lord, that is the Visara, my lord, that is the chemical analysis is awaited, that is kept pending. Otherwise, my lord.
Homicide to it, I mean, of course, we cannot say anything,
Some
but
independent.
it appears to be prima facie an accident.
Yes, my lord. In the, my lord, that is, my lord, from the, my lord, there is a witnesses, till today, my lord. Till, my lord, goes today, my lord. It's more like that, my lord, that when, my lord, there is gambling is going on, my lord, police, my lord, made a raid. And at that point of time, my lord, those who are participated, my lord, they ran away, run away. That is also there, my lord, reflected. Now the other part that, my lord, because of the, my lord, monetary transaction. And
They are the
that
organizers,
thing
they
is, my
said
lord,
with
that
the
is
organizers.
reg-
So actually,
regarding
it should-
that
they
monetary
should not be
transaction and
granted
that is
bail
the
for such
other
acts.
part, my
Lordship,
lord.
there were two FIRs, my lord. First FIR, Lordship, is page 12, my lord. On the date of incident, my lord, the police came and police lodged an FIR, my lord.
All are participating. They must be participating, all of them. Prima facie. Prima facie appears to be. A death appears to be an accident, prima facie. Something else might emerge after investigation, but prima facie appears to be an accident.
Till today, my lord.
What is the bail objection say about them?
My lord.
No, verbally, what you know. The IO has submitted a bail objection, objecting to the grant of bail. Full stop. The contentions of the IO in the bail objection correlate with the allegations in the FIR. Correlate to the other materials revealed by the investigation that the accused Raghubir Jadhav, his wife Sabitri, and Manoj Shah were the organizers of the gambling, where various other persons, including co-accused, used to assemble and indulge in the gambling. And on that unfortunate day, the husband of the informant had also come there, and upon fear of police coming there, he ran through a dangerous road and died falling into a pit. His dead body was recovered a few days after the alleged date of incident. Full stop. They were also arrested on the same day.
Same day, my lord, all same day.
Both the accused persons here. Here, all three are there.
Yes, my lord.
Manoj is not here.
Manoj is there, my lord. Place number 1.
His name is kind of,
Place-
Manoj Prasad Tha. He's the apparatus-
Manoj person, yeah. All the petitioners here in also were also arrested on 1/11/2025. The investigation has revealed sufficient incriminating materials against the petitioners. And supported the basic contention of the prosecution at this stage that they were the organizers of the gambling activities and stuff. Should we make a distinction because irrespective of gender, every crime is a crime, Savitri Devi. Because otherwise I'm not inclined. Let the investigation be completed.
Lordship,
Because they were the organizers.
Lordship, allow me 1 minute.
Yes, sure.
Lordship, may kindly see page number 12, my lord. This is first FIR lodged by the police, my lord. On the date of incident, police came, my lord, and they lodged an FIR. This case was registered with intelligence case number 183 of 2025, my lord. In this case, my lord, petitioner has got bail, my lord. The lordship will find it page 30 is the order, my lord.
See.
This was registered under section 14 and 15 of Games and Betting Act, my lord. With regard to Games and Betting Act, they have got the bail, my lord. That order lordship will find it page 30.
Yes.
Page 30, my lord. Operating part lordship will find it page 31. Now, serial number B, G, and H, my lord. Now, subsequently, second FIR was lodged by the wife, my lord, after 10 days, wife was victim, my lord. Now, for
These kind of activities can
Yes,
be
sir. So the-
continuing also.
yes, lordship will see, my lord, on the very day, my lord, for first, the incident, my lord, FIR already was lodged by the police.
Because, my lord, FIR is lost after the recovery of the
Yeah.
dead body, my lord.
Yes.
Now, lordship
Because,
will
my
see-
lord, that is the date of incident,
uh,
is 19/10/25, my lord.
It underwent
My-
the whole
Yes, my
matter underwent a different dimension.
Yes,
It underwent
Yes, my lord.
it got a different color
Yes,
after the dead body was
Yes,
recovered,
my-
right?
If lordship is the contents of the FIR but was lodged by the police and lodged by the victim's wife, my lord, there is distinction, my lord. If a police lodged by the FIR lodged by the police says, my lord, when the police reached the my lord, spot, my lord, they saw the vehicles there, my lord. After coming to a police has come, they ran away, my lord.
All right.
Lordship, I'm praying that this lordship, since we are not connected to death, my lord,
All right. Okay.
will you kindly consider.
Despite the this adverse materials against the petitioners, I take note of the fact that there seem to be reasonably good progress in investigation, and several of the co-accused have also been granted bail by this court in fight orders passed in other connected bail applications today. In the given facts and circumstances, despite the despite the adverse, the given facts and circumstances, the accused petitioners herein are also allowed to go on bail of ₹30,000 each with a surety of the like amount each to the satisfaction of concerned learned court. This and subject to Hegata conditions. First, they do conditions. They shall not indulge in any activities violative of this.
Much obliged.
This kind of gambling activities can bring financial ruin
My lord.
in
my-
many
my-
families.
My lord, that's true, man.
That is why it's a social evil. That's why it's a penal offense.
Time being 30.
Timing. Oh. What are
Earlier rejection order is at page
Yes.
41.
Yeah.
86 days in custody.
I see. It was just case. Petroleum.
Yes. And explosive substances like subsequently added, for which it has become 90 days.
What is the progress of investigation?
Investigation regarding the, my lord, two accused persons not yet arrested, regarding the present three accused, present accused persons, my lord.
Here too,
Here two
Two is
persons,
for-
two accused persons, two.
One were earlier granted bail by the learned judge.
Investigation was substantially progressed.
progress. I think they can allow the distance. Let's see.
No, my lord, there are sufficient materials against the.
Yes, sir. Materials are there. Let's have a look. I'll have a look.
Yes.
It's reflected in the last order sheet also.
Yes, yes. You're Mr. Chakraborty?
Yes, sir.
P. Chakraborty, P. Bhatakura. Learned edition PP. আমার আগৰ অর্ডারটুকু আপনি second, third, fourth paragraph. Or second, third, fourth paragraph. The Mr. Chakraborty learned petitioner counsel fairly submits that earlier bail petition was rejected on 31/10/25 by this court in BA 3379 of 25, comma, a copy of which has been annexed. The up-to-date case diary has been received. The learned additional PP submits that though investigation has fairly submits that though investigation has progressed, but there are sufficient incriminating materials against the present accused. They suffered burn injuries, some of them. The petitioners were arrested on
But arrested on 30th, forwarding the report to the 31st of that is at page
were arrested on 30/10/2025 and first
38.
remanded
38 and
38.
Forwarding report is 31st of August, page 16.
38, right?
Yes.
And first remanded on 31/8/2025. And it is submitted that they have completed 86 days in custody. Considering the above aspect and also progress of investigation, comma, despite the incriminating materials revealed by investigation, dash, the accused persons are allowed to go on bail of rupees 30,000 each, surety of the like amount each. Shall not hamper or tamper with evidence, shall be available to face trial if one commences. Return back case trial. Bail petition stands disposed of. Sivsagar, Session Judge Sivsagar.
And deeply obliged.
Supplementary 50.
There is an order for some instruction from the other side, man.
Okay,
About compliance of 48 mile.
okay.
Order is dated, lost will find 10/11/25.
10/11. Twenty-two C.
Yeah. So that is the, I am not on that. Only Maria Lordship, can
Yes.
see page 21.
Okay. This hurdle, let us first negotiate.
Our case is that, my lord, this was not served to the person who was outside the state. And he was in the Mizoram, and we have given the hotel receipt also. So that was to be inquired with, my lord, that was the reason. Signature,
Now-
page 21 is the
47 is there, grounds.
47. I am not, no objection, but it was signed by that.
So it
Not
was-
on the ground, my lord. It was not served to the proper person at all. They did not have any information, my lord. Somebody else might have received it, my lord, because the person whose name is there, the brother of the accused,
Yeah, Yamin Ahmed
Exactly, my
as part
lord.
of-
And signature is kindly signature verify from the affidavit, my lord. We have submitted affidavit, his name,
To,
and you have kindly page 20.
otherwise contents are there. Though I have
Contents
not-
are there.
Though I have not read.
The contents are there.
Bengali also is there.
Yes, that is there, but I am not on there.
Regarding.
I am on the page 20 and
47 notice is fine.
Fine.
Huh? And here some narration is there.
My lord.
But your contention is that.
Page 20,
is
page 20, my lord.
20. The contention is that the
person
48
who-
notice was not served.
Not served at all, my lord. This person there might have put the signature, my lord. This person was your lord's kindly see from in the Mizoram, my lord. He does my lord business, my lord, at Mizoram. And he was at that very time in Mizoram, then how his signature at foreign was, my lord. And this is not the, my lord, spelling also, my lord, wrong. So that was to be informed, my lord.
The disputed fact.
Yes, so that's why, man, it is there to prove. Whether it is, my category statement is that, my lord, this is not signature of the person whose name is there.
Yes.
So also may verify from the affidavit in the petition itself, my lord. He came and filed the affidavit on behalf of the accused.
Okay. This is this hotel receipt is from Mizoram, right?
Yes, yes, sir.
Okay. Scholarship.
He resides in Mizoram, normally, my lord. And there is no other brother, only his mother is there in the, and it is my lord within half kilometer from the house of the petitioner as well as the Thana police station. Or maximum 1 kilometer. In Koimon town. my lord.
Are you in a position to
Madam,
verify
that is,
this?
we have communicated, madam. Till now, we didn't receive the mallet. That is the mallet. That is the instruction, madam, regarding that part, madam. Because only now the question is that, madam, the allegation is that, madam, there is a 48th notice. Who is mallet, madam? The recipient is not the brother, madam. Is not the madam relative. That is the contention. Otherwise, prima facie, if mallet we look into the mallet notice, it is completed, madam.
Yeah.
Because
Narration is seems to be okay.
okay, madam. So only that
It's
part, madam.
bilingual also.
Yes, my lord. Only now that is the.
But
speaker, my lord.
yeah, if,
And there are some, my lord, situations, my lord, when, my lord, somebody is apprehended, he will introduce the person, my lord, to whom to give, whom not to
yes,
give.
yes,
my
that's
lord.
true. But since he's stated to be the brother,
Yes.
Own
brother,
brother, my lord.
own brother. So
Own brother.
suppose
And
there
he
are
was-
materials to see, say if there are materials to indicate that that brother was never there, then
There could
obviously
have Mizoram hotel also, my lord.
it would be a fictitious person, and would
This is the
amount
only
to
thing, my lord.
it would amount to not giving the notice
Well,
if it is a
This is
fictitious
the
person.
case, my lord, this is.
So, but that is a disputed fact. We have to see. I don't know. That's
But
why I asked
That's
whether you
what
are
the last order, my lord. Last
whether you are in a position to say this. I've seen this order 10, 11.
To my information, they have
Nicely
come to the
written.
house of the accused, my lord.
Nicely narrated.
The other day, police has come.
Mhm.
The other day, they said he is in Mizoram,
will be
so
diff-
they did not find him, my lord.
Then, my lord, we give us a short date, my lord. In the meanwhile, we will again, my lord, send an instruction, my lord, notice, my lord, to the concerned, my lord, investigating officer, my lord.
CD has come.
Yes, CD is available with us, my lord. CD is available with
But
us.
since
Only my lord was pleased to, my lord.
Because otherwise we'll have to go into 37,
Yes.
right?
the 37 will not come, my lord, if by
We are not going into
Your lordship
37.
is aware of this.
Yes, we are not going into 37 now. First, this bridge.
And your lordship that later that my Keshavgadi, Kashi Reddy, my lord, your lordship can be just a paragraph, my lord.
Yes, sure.
Your lordship has seen, I think. Kashi Reddy, paragraph 18, just have a look, my lord. It will
This
take
bridge
a-
we have to cross first.
Yes. Paragraph 18. Your lordship will find 18H, my lord. Or G and H, my lord. G and H. When an arrestee pleads before a court that the grounds of arrest were not communicated, the burden to prove the compliance of the Article 21 is on the police authorities. Your lordship got it. 18G. This is the latest judgment file. And G and H, your loss kindness, H. The grounds of arrest should not only be done to the arrestee, but also to his family members and the relatives, so that the necessary arrangements are made to secure the release of the person arrested at the earliest possible opportunity, so as to make the mandate of so meaningful and effective. That is very important. A simple notice will not give it much.
Is there any, contemporaneous, it's called, that word, contemporaneous record in the case diary about whom it was given to?
My lord, here in the, my lord, CD entry, my lord.
Because this is also the law, no? Whenever
Yes,
the
my lord.
contention
No, my lord.
is made,
Yes, my
a
lord.
disputed contention, we can always look up the case diary. Look up the case diary.
In the city, my lord, that entry is there, my lord. Regarding, my lord, service of 47 and 48 notice, my lord.
But to whom given us an
My lord, that details is not there because, my lord, the 48 is, my lord, that is copy they have, my lord.
This notice, he could have,
My lord, may I kindly see, my
this
lord.
could have, this you can submit before the IO also, this hotel, because this may be necessary. Time of trial also.
48T, it says an entry of the fact as to who has been informed. Your lordship,
Yes.
BNSS one.
Yes, it is there.
There must be entry to whom it was given.
Sir, can you show me that paragraph where the statement has been made? You can show.
In our,
Yes, yes.
petition.
Because I have to reflect in the order.
Exactly. I'm obliged to us. Your lordship, kindly see paragraph 7. Paragraph 7.
Okay.
I lift your lordship, my lord.
No, it's okay.
Could I get a statement you have given an oath, my lord?
It has been written that it's conveyed to family member.
Yeah.
But whether
Yes, my lord, that word is there.
that is there, but they have there is a statement on affidavit, and along with the receipt
Yes.
that whether it is.
And my lord, these are the matter, my lord, then again, my lord, another investigation needed. my
Yeah,
lord.
disputed fact actually.
That we also feel, my lord.
Disputed fact.
Because, my lord, in the city, when there is an entry is there, my lord, there 47 and 48, my lord,
They should have. I mean, sometimes they can miss it, but it is best to write whose family member name.
Yes, my
Name.
lord, that should be, my lord, that should be.
Section 36 also is there, my lord, BNSS. Inform the person arrested unless the memorandum is attested by a members of his family that he has a right to have a relative or friend on file. That is section 36. And 48(3) also, my lord. There must be endorsement to whom it was given. 36 is also important, my lord. 36(C). I hope your lordship understood that.
Dictate, you just check if I cross check the
My-
facts
my-
when
my-
I
my-
dictate.
I'm
Have a seat.
obliged to us.
Third non-senior counsel. 10-11 ও ধুনীয়াকে লিখা আছে। We can take first to 10-11 order to first to idea মাৰিছে। Mommy. দুটালৈ থাকক মই নিজে মতে লিখিম এইটো the learned senior counsel submits that for the moment he is not going into the merits of the matter and the applicability of the rigors of section rigors of section 37 of the NEPS Act as penal provisions pertaining to commercial quantity have been given at this stage. It is submitted and contended that primary contention of the petitioner at this stage is that though notice under 48 narrated some grounds of arrest in both English and Bengali, but it was purportedly given to the brother to Yamin Ahmed Asfarak, the brother at page 21 or so, the brother of the petitioner. Drawing attention to para 5 of the bail petition supported by affidavit, not para 5, no, para 7, sorry, para 7 of the bail petition supported by affidavit. It is stated and submitted that though the notice indicated, notice under 48 BNSS indicated service of notice to the said Yamin Ahmed so-and-so, the younger brother of the petitioner, but on that day he was at Mizoram and stayed in Hotel Serene Stay for the period from 9/6/2024 to 9/6/25, I think you typed it wrongly. From 9/6/25 to 14/6/25. I think you have typed it wrongly, otherwise it will be 14/6/25, and he was not present at the place of occurrence where the accused was arrested. As per the materials, the accused was arrested on 12/6/2025. Where was he arrested? Place?
12/6/25.
12/6. Where was he arrested?
At Korimganj.
At village. This
Yes,
place.
your lordship will find.
Where was he arrested? Near under the jurisdiction of Korimganj place.
Korimganj.
He was arrested within the jurisdiction of the
Your-
Korimganj police station.
Your lordship will find FIR is page 14 and forwarding report is page 16, man. 16. Forwarded to CGM Korimganj. Sribhumi.
Sribhumi.
Yeah, page 16.
Yes, yes.
Your lordship what is? 16.
Got it.
Annexer 2.
Korimganj Sribhumi / full stop. The copy of the hotel receipt has been annexed as Annexer 4 and the notice under 48 as Annexer 5. Full stop. I have carefully perused the notice under 48 BNSS as well as the hotel receipt. Hotel receipt is of 14/6, isn't it? After the date of arrest.
No, because after when you came to know, when he came to matter, he was not there. Your lord can paragraph 7. When
Yes, I have read.
we obtained the certified copies, then we came to know. Man.
Paragraph 7. One typing error is there, I think.
Yeah, I'm sorry.
9/6/25 it should be.
Yes, it should be. Yes, but 14/6/25. That I'll correct in your lord's friend.
It is submitted that when the
After getting
brother of the
certified-
accused came to know about the arrest
After
of the
getting
present
certified
petitioner,
copies.
he moved out of the hotel
Yes.
and obtained this receipt dated 14/6/2025. As per the statement in para 7, he was in the hotel since 9/6/2025. Though it has been wrongly typed as 9/6/2024. Full stop.
The hotel receipt is correct, man. The receipt is correct. My weak complaint mistake. Sir.
It's a risky business, Mr. Prosecutor, because of the commercial quantity.
But
And my-
Bianca must say, my
on
lord.
entry, my lord, we have completed, my.
Hmm.
My lord,
The
if it is not that, my lord, then.
learned additional public prosecutor has placed the case diary before me and draws attention to the relevant portions. This it is endorsed in the case diary that notice under 48 was provided to family member of the accused, but the name of any such family member is not mentioned. Stop. Yeah, it is there. Family members, ideally it should be mentioned. Truth. It is submitted by the additional PP that there is no infirmity in providing the notice under 48 BNSS. During the hearing, the learned senior counsel has drawn my attention to para 18 of the Kasi Reddy Ubetulin, which may be reproduced herein below. Full stop. Thus, I find that it has been laid down emphatically by the Honorable Tax Court that the grounds of arrest has to be provided to the family members / relatives of the accused. Next paragraph. It can be said that in a way, the notice under section 48 BNSS is even more important than the notice under 47 BNSS, though both are mandatory requirements under the law, under the statutory law as well as the law laid down by the Honorable Supreme Court. This is because once on behalf of the detained persons, it is the family members or relatives who would be in a better position to take steps to prepare for his defense and engagement of counsel. Full stop. If the notice under 48 BNSS is provided to any fictitious person, then it would not amount to compliance with the spirit and substance of section 48 BNSS. Full stop. In such a situation, it can be said that it would amount to not providing the notice at all. Full stop. Needless to say that the settled law is that in case of failure to provide the notice under 47/48 BNSS, the under trial detention of the accused continued under trial becomes untenable. In the present case, although penal provisions of commercial quantity are involved, separate paragraph are involved. However, upon perusing the statements in para 7 supported by affidavit, semicolon, the hotel receipt and the endorsement in the notice, semicolon, the relevant portions of the case diary, dash. I'm of the considered opinion that the petitioner side has made out a reasonable possibility of fatal infirmity in the notice under 48 BNSS, even though the grounds are narrated. Full stop. In such view of the matter, and in terms of the settled law, I find the accused to have become entitled to bail. Accordingly, is allowed to go on bail of 50,000, no? 50,000 with 102 of the like amount.
With a special
To the
judge.
satisfaction of the concerned learned court, special judge, and subject to the following conditions. He shall cooperate with remaining investigation, not hamper temporary dividends. And thirdly, he shall not in any manner indulge in any illegal activities, including any activities prohibited under the NDPS Act. Violation will entail cancellation of the bail, the return back the case diary. Can I keep the case law?
Yes, yes.
Return it back.
Your loss. It is from my side, it is given to the court.
I tell my law clerk to
Yes.
just take out.
Obliged to us.
Actually, it's as I said, I feel we indulge, we conducted an adventure, but because it's a fair adventure, because when there is doubt, it is always the beneficial thing should be taken. And the thing is that while so much training is being given to the police, right? So that's why as part of this training, you can also convey. This should also be trained that, see, if you admit your mistake, honestly, that is respected. That will always be respected. We always encourage honesty. If you have not followed, say it. I'll learn next time, but no manipulation. that is not to be encouraged, that I have not, actually followed, then I try to make it out. That will be bad. That is not the spirit, that kind of complaint. No, I'm not saying that it's not absolutely proof. There's a possibility because they may get scared that, higher authority will suspend them or, some got bail or they will be, they scold them. But that culture should be created, that you should follow. Now learning window is not there. I should follow. But if I suppose fail to follow, let me admit the mistake instead of manipulation. That's the best. Then you learn. Tomorrow you don't make that mistake. That's it. We have to create an honest system. It's so important. Okay. I'll just 5 minutes.
$52.
Yes.
Make business.
So Viswas.
My lord, the petitioner before your lordship happens to be an assistant headmaster of a school, my lord.
Okay.
He is being in custody for 45 days.
Return case diary. Bail petition stands disposed of.
Deep level.
Time upon it. That took a lot of time. Should we touch one or two matters or? So many matters still left. Should we start with admission or anything very urgent? Because
13. Admission item 13.
Yes. You are for the respondents?
And for the petitioner also.
It's a criminal revision.
Yes, Lordship.
Mhm.
Against order dated 19/6/2020. Lordship is going for final disposal.
No, there will be no time today. Against interim compensation?
Yes, Lord.
Against interim compensation?
Yes, yes.
So what do you say? Another day? Should we keep it for another day? Or I mean, there's not much time. 5 minutes we can do. An interim order, right? So there's an interim order.
Yes,
so-
Lord, the interim
so
order is there.
He will be aggrieved if it continues. 1 lakh as interim compensation within 60 days. Trial court has directed the petitioner. Respondent has filed. in response to opposing this.
So there are some parameters laid down by the Honorable
Yes.
Apex Court Lordship, which was not followed.
Only after plea of guilt is
Yes.
decided, then only it can be. It
Yes,
was,
sir.
I don't know what stage it
The
was
High
given.
Court has the jurisdiction to refuse the interim compensation. It should not be passed in a mechanical way.
No, it has the jurisdiction,
Yes,
no
sir.
doubt, no doubt.
And section
No, no.
139 will not come into play while considering the section 143 of the NI Act. There is a judgment. Lodge.
Paucity of time, paucity of time, full stop. You can suggest me, no point admitting it will be, might cause him prejudice. No, it will get late. If it goes to the hearing list, it will get late. You know, you never know when it will come. So let it remain at admission stage only.
Yes.
Paucity of time, matter could not be taken up, full stop. The
They call for the scanned copy of the record. Lordship.
we have not called for. We have not.
Earlier, perhaps.
Oh, it's a part hard matter.
What are we?
Oh, I see. Then I'll have to take it only. Should we keep it on Thursday? Should we keep it on Thursday?
Be Lordship, next week, Lordship. I have some.
Next week, 2 days I may not be available, 3rd and 4th.
Fix it thereafter.
Thereafter.
It have got another date in another.
Okay.
case as well.
Can you suggest me a date? List the matter, interim order granted by the order dated 18/8/2025 shall stand extended. The matter is as reflected in order dated 15/10, the matter is part heard by me. List the matter on, you can suggest a date, 8/12.
8/12.
Is it a hearing day? Take it on a hearing day. Then
It's
we can
Monday,
take it.
Lordship.
Oh, no, don't take it on Monday. Take it on Tuesday or
Like-
Thursday.
Can it
9,
be on
12?
9th, line 9?
Yes, 9/12.
9th. 9th.
Part heard থাকিব। Part heard হয়ে আছে।
Interim order pass earlier.
Yeah, I have to give.
Yes.
You study those laws and
Yes, sir.
we can discuss then. And over, I think we should go for mention, I think. No,
Lordship.
we have to go faster, still faster,
Back mention item number 56, it's an IA.
No, don't worry, I will attend to all of you. I'm not rising without attending to all the learned councils. So just relax. Tell me. Yes. Yes.
Number 56.
56.
This interlocutory application was filed in AB 2696.
So you told me to correct what?
Yes,
What
the
was
full
it?
cost title and
Acha.
so now because of this, this was the main petition was filed on 12/11. Now almost 10 days have gone past and the CD is already available
Acha,
with
acha.
the
It
honorable.
was for correcting some cost
Yes,
type.
yes, name cost title, just one line and then there is a few correction in the translated type copy of the FIR.
Item number 40?
56.
56.
Orders in the order.
A plea orders, huh? Paucity of time. This IA was filed for a correction in the bill application. We can take it up top of the list
Yes, yes.
and correct it.
Yes, yes.
When should I fix it? Wednesday or
Uh,
Thursday? Top of the list.
Friday.
Don't take it on Thursday, will be better. Less matters. You have some problem on Thursday?
Thursday will be 27th.
27. Is it okay for you?
Yes, yes, ma'am. Top of the list.
Top of the list, should I say? Top of the list or
If it is
after the motion matters? Because
at 2. Or else at-
okay, at 2.
Yes.
Because I wanted to, I want to take it up on the next day.
Yes.
Every day it's coming and not reaching.
At 2 then.
Or 2.
Oh, yes.
We'll take it up on priority. It's a correction. We'll
Yes,
do,
yes.
do it. Okay.
Okay.
Yeah, you retain the CD. Retain the CD. On Thursday only we fixed.
Yes.
27.
Okay. Item 46, my lord, a small criminal division hearing matter, my lord. May kindly be taken on Thursday, my lord. Very small, it will hardly take 5 to 7 minutes, my lord.
It may be easy for you. It may not be easy for me also. It may not be easy for me. Anyway, Thursday, okay.
Thursday, well, 46.
46. 14 matter. It will automatically come in the top of the list. in up
Almost it is
higher up the list.
55 years old.
Yes, yes.
My lord,
Thursday. Huh? Thursday, Rakhi.
may I please, your lordship?
46, yes.
Item number 42, my lord. This may be listed for admission hearing within 1 week, my lord. 42.
Paucity of time. No, it is orders, it has come for orders.
Yes, my lord.
You want it to be fixed for
Admission. hearing,
admission.
my lord, shortly.
It has not been admitted,
No.
has it? 42. List after a week.
Must,
List after a week in the admission column.
must.
Please, your lordship. Lordship, I beg to mention for item number 44, your lordship. On the last occasion, your lordship, the additional PP was about to file the objection, your lordship.
It's a bail petition,
Lordship,
Criminal appeal.
Criminal appeal.
bail petition, bail petition.
Yes. 44, your lordship. Lordship, the matter may be fixed on some days, your lordship. Short date maybe.
Lordship, I'm appearing for item number 40.
Just a minute, madam. This is for paucity of time. When should we fix it?
Lordship, it can
Sarma?
be fixed on 28, your lordship.
No, no, don't take it, take it next week. 28, take it next week. No, no, when should we fix it? 44, item 44. Except third, fourth. Third, I mean, it may come up before another bench, no problem.
My lord, service from
Yes.
44. My lord, here, I will have to verify, my lord, whether objection filed or not, my lord.
Is it?
It's not filed, your lordship.
Not,
Not filed.
Then after one.
Two-
days, after 2 weeks.
Two,
After
Lordship, 1 week maybe. See, the
2,
accused
2/12,
my lord.
Tuesday, next Tuesday,
No, my lord, we will have to file our objection if not filed, my lord.
if not fine. No, no, we'll adjourn it further if necessary.
My lord.
Okay, after 2 weeks you want,
After 10 days, at least 10 days, my lord.
after 10 days.
My lord.
Lordship, a date may be fixed, your lordship.
You suggest a date, please.
My lord.
You suggest a date. Today is 24th, right?
My lord.
This will be 4.
Hmm?
5th,
Short date only.
huh? 5/12.
My lord. My lord.
5/12. Next,
Oblige, your lordship.
admission.
LCR has not been received.
Connect.
LCR has not been received. Like, kindly call for the same again and by fixing a date,
Okay.
24,
Is it,
22.
okay. So, can be admitted actually, okay. Call for the TCR not yet received, call for the same. List after 3 weeks,
It's,
or
2
2 weeks,
22 meter.
2 weeks.
May I please, my lord? Item number 19, my lord. Matter may be taken up Thursday, my lord. My interim may be continuing.
Your lordship, actually.
You're for the respondent?
Yes, your
Yes.
lordship, respondent number 2.
Tell me.
Should kindly take after 8th or 9th December. Your senior counsel will not be present out of station.
Then no problem. I don't have any problem. If you can accommodate, let it be. Or 8 or 9, she has some problem. Paucity
Okay,
of
my lord,
time.
my interim may be continuing.
Interim will be continued till the next date of listing. So 8 or 9, after 8 or 9, right? 8 or 9 will be. Calendar. So can suggest a date.
It may be 10, my lord.
12. A hearing day you take. Hearing day, 12, 11.
11.
Your blessed.
But the item number 18 may be listed, if possible, on 26th. And if not, then after second week of December.
Second week of December.
If possible, that may be fixed. first.
This can also be on night, 11, 11, 12. 11, 12, 18. Yes. Sorry.
Item number 5,
No problem.
that has been fixed on 28. But my instruction is to withdraw this bail application.
Is it?
5.
I think I might have signed the order also. Otherwise, if I have not signed, then we can change it. You want to withdraw, you file it.
Lordship, it will
Withdrawal.
take time. My instruction is to withdraw today itself. Kindly, Lordship, this much.
I don't know, so you have to check, huh? I think Gosia called me. We'll check it. Okay.
Deeply obliged.
Then inquire later tomorrow, he'll tell you.
Obliged.
Wait, lordship.
Yes.
Lordship, I beg to mention item number 41. Lordship, in this case, the notice has already been served upon the respondent.
Mhm.
It is a maintenance matter. The petitioner is not receiving any maintenance from the husband.
Okay.
And with regard to the two minor children who are with the petitioner, they have also been awarded only rupees 3,000 per
Okay.
month each. I pray that a date may be fixed, Lordship. Nobody has entered appearance also.
I see. They have been served.
Yes, Lordship.
You are
Served.
appearing as legal aid counsel.
Legal aid counsel, Lordship.
Paucity of time. It is submitted that though respondent was served, but none has appeared so far. Full stop. This is at the stage of, it has not been admitted.
No, Lordship, it has to be listed for admission.
List the matter after, you suggest a date, the third week of, after
it-
2 weeks,
If it could be on 17th December,
17/12, in the admission column.
your Lordship.
Left,
Deputy-
my lord. Lordship, my item number 19, my lord. 11 is not convenient to me, my lord. Yeah, date may be sent for 12 or 13 anyway.
13.
Yes.
He's there at the council. Those
I-
kindly inform him.
I,
Don't forget, huh?
Yes.
Please inform him because otherwise he will come on
okay,
that
okay,
day. 13. No, 19. Item 19, instead of 11, it will be 13.
Yes.
Your junior can inform, kindly inform. You inform.
May I praise your lordship? Lordship, item number 43, lordship. As per order dated 1911, lordship, we have taken the service upon respondent number 2, your lordship. It's complete. So kindly the matter may be listed for admission, your lordship.
You have taken steps for 43. It is submitted that steps of notice upon respondent
2.
Respondent number 2 has been taken, but service report is awaited.
Yes.
no? List the matter after
1st December.
3 weeks
First week of December.
on 5/12/2025 in the admission column.
Much obliged.
Item
Item number 20.
22.
Before 12. Item 22.
22.
Criminal petition.
When do you want it?
That's it.
When do you want it?
Item number 20.
When should I fix it?
New one. 10, 11. Before 12.
Before 12.
Immediate, Lordship.
10, 10, 12.
Obliged.
Map results. Item 5, if it is signed, then let the matter come tomorrow for withdrawal, lordship. If it is signed, lordship.
Acha.
Huh?
Huh? What is the way out? Can you make a mention?
For withdrawal, lordship.
No, I'm trying to give you the relief actually. কি কি কৰিব পাৰি? Can we do? Yes. একো নাই। I'll look into it. Don't worry. Otherwise, you make a mention tomorrow. We'll take it up. You make a mention tomorrow. If not, huh? Don't worry. Get it done. You want to withdraw? Why should you be prevented?
May it please your lordship, item number 47, a date may be fixed, your lordship, is a 2014 matter, criminal revision.
Hearing?
Yes, your lordship, item number 47.
47?
Yes, your lordship.
Sure. Oh, hearing have come at the last 2014 matter. Oh. This is true. Today, do one thing. Come on. December. Let us fix it on 10/12.
Yes.
Hearing day. Huh?
Yes, sir.
It will automatically come in the higher up since 14 matter.
Yes.
Then
Obliged.
we'll try. It's a revision against conviction or other matter?
I'm not aware.
Not
of
sure.
that. Obliged.
You study, then you do.